This morning to the first annual, hopefully annual Top 65 seminar. I'm Allison Chen. I'm the incoming president for the ACC's Mountain West chapter. There's a couple other board members in the room. Abby and Saul, you're board member now, right? Saul's a new incoming board member, and Gordon Walker. Am I missing anyone? Don't think so. So I want to thank everyone for coming to this. It's a new event that we're hoping to start and have it as an annual event. I'd like to start off by thanking our sponsors this morning. Without them, we wouldn't be able to have this event. We have Holland and Hart, and with us this morning is Brent Johnson, who will be our first presenter. We also have Trustco, Josh Whitworth, and Arnold and Porter K. Scholar, and Greenberg Chare, none of which are here yet, but they'll be here soon to present by their time. If you're not already a member of the ACC, I would try to invite you to join. If you have any questions about it, you're welcome to speak with me, any of the other board members, or to speak with Sarah Mattern, our executive director. We should probably get a trial membership if you want to see about the forums or the networking that's available. I don't know about any other ACC members. I use the forums quite a bit. I'll also go into the forums and ask questions. There's often discussion about different sections if you're working on a contract. It's a nice way to network with your peers. So, and if you have any questions about the large law, if you're in a law firm that has more than 9 attorneys, there's actually a discount. So please talk to Sarah about that. If you are trying to get CLE credit, don't forget to sign in with your bar number. And this event is also being webcast to Idaho, and then should be available on our website for a couple of months. So if you have any staff or any friends that you would like to view it, it should be available for them to view. If you want any of the handouts that are the slides, we can also have that distributed to you by email. And without any more to that, if you stay, at the end of every hour, we're going to have raffles for $100 gift cards, some nutraceutical products, and also we have 2 ZAG baskets. So if you stay through the whole thing, at the end of every hour, we are going to have your time. So just a little bit of a bribe to get people to sit through the CLE. And with that, I'll let Brent Johnson begin.
Thanks. And after you hear our presentation, you'll understand why these bribes are necessary. I've never had that before, where it's like, hey, if you stay, not only do you get CLE credit, but we'll give you a treat. So anyway, I came down this morning from Park City, where I live, and I'm still sort of recovering from the experience. So please bear with me here as we get rolling. Okay, Prop 65. Most of you probably have some familiarity with it. In fact, anyone who's ever traveled to California has familiarity with it, whether they know it by this name or not. But we'll start from the beginning and we'll work our way to today. It's actually called the Safe Drinking Water and Toxic Enforcement Act. It was adopted in November of 1986. I started practicing in Los Angeles. I graduated from law school in '87. Did a clerkship, started effective 1988. And so it started in '86, and the interesting thing there is it took them, they didn't have a list yet. So they had the law, and then the OEHHA, the Office of Environmental Health Hazard Assessment, came out with their first list a year later. And I got there right at the time when this stuff started getting rolling, and it was a big deal. The vote was 63% to 37%. And, you know, if you're familiar with California, if you've lived there, you understand that it's become progressively a rather liberal state in terms of its politics. But, and this could be viewed as a fairly liberal proposition. But in the same year, George Deukmejian defeated the mayor of Los Angeles, Tom Bradley, for the governorship, 60 to 37%. So just from a political standpoint, it's kind of anachronistic in the sense that a Republican won an overwhelming vote for the governorship, and yet we have Prop 65 at the same time. And the ideas were, we want to keep toxic substances out of water. We drink that, makes sense. We want to require companies to warn the public before exposing them to toxins, okay? And then we want to permit private citizens to enforce Prop 65 in court. The bane of our existence is that third checkpoint. But that was the three stated goals. It seems noble enough. This is the standard, this is the language, this is what we all live with. No person in the course of doing business shall knowingly and intentionally expose any individual to a chemical known to the state to cause cancer or reproductive toxicity without first giving clear and reasonable warning to such individual. There's the language. We deal with it all the time. Now, what's fascinating here is that while the language focuses on the warning, that was not the intent of the people who proposed the legislation. This is what they really thought at the time. It was Ken Kaiser. I think he's at Davis now, but at that time he was the former director of California Department of Health. And this is such a great quote. I mean, really think about this. Prop 65 warnings on products will probably be limited in quantity, as businesses seek to avoid listed chemicals if they can or seek processes that will lead to a reduction in chemical exposures. That was the real underlying idea behind Prop 65. These warnings are going to make companies so scared that the threat of having to do a warning, that they're going to fix their products, not just for California, but for the entire country, perhaps the entire world, by removing the chemicals that we identify as being toxic or carcinogen or causing reproductive harm. That was the idea. They're going to fix it. There's not going to be a lot of warnings. This is the current Prop 65 warning. In a little while, Nathan will be discussing a bit how the warning is going to change in the next 2 years, but this is the typical classic warning that you will see or that you will put on your products or your premises. Okay. Now, many of us may not know, most of us know that you can find the list. You can get the OEHHA list and review it, see what chemicals are on it, and if you can try to figure out whether or not they're in your products or not. But very few of us really know how those chemicals get listed. And here are the ways. First, you can have chemicals that are identified by reference in California Labor Code Section 6382. Okay, that's the first way. California's qualified experts. That is the primary mechanism for which chemicals get listed on the Prop 65 list. Authoritative bodies, and then products that are formally required to be labeled. The Labor Code, this is basically occupational health hazard chemicals, and they're identified by the World Health Organization's Agency for Research on Cancer because they've determined that this chemical causes cancer to laboratory animals or humans. So this is, I mean, that's the primary way that a labor code section will implicate the list. Notice that you get I don't know, how many of you follow the register? Do anyone follow the California Register to see if you do? Okay. And do you do it just to stay abreast of what's going on, or is it, okay, yeah, it's, that would be a tedious task, but congratulations.
That's what they pay me for, so.
Yeah. So they give you a 30-day period to comment. If you follow the regulatory notice register in California, you see a chemical come up under this code section, you get a 30-day comment period. If you've got a real problem, you can comment. Oftentimes, nobody does. Next, the state qualified experts, these are the SQEs. You have two committees, the Carcinogen Identification Committee and the Developmental and Reproductive Toxicant Identification Committee. And these are the two agencies that sit down and really make the hardcore determinations for what chemicals are on the list. And the reason we have so many chemicals on the list today is because of the active participation of these committees. They get together once a year, and they've spent all year long reading journals, medical journals, papers, international materials, and they come in and they're prepared to talk about what new chemicals need to be added to the list. This is quite long, and if anyone wants this, well, actually, I think we may afford it to them. Have we afforded them this?
It will be available.
Okay, yeah. I don't need to go through this in detail, but the bottom line is you have another notice and comment period here if you're following the register, and you can try put your 2 cents in and try to convince them to change their mind. But when you look at this in detail, you realize that unlike a lot of federal regulations, the comment periods are really truncated. They're not really interested, it doesn't seem to me, in hearing from anybody on this, but because it's a government agency, they do have a period of time where you can comment. And if you're in an industry group, you might be able to aggregate your effort and get a little more impact than individually. Then you have authoritative bodies. And these are the EPA, the FDA, and you can see the other ones, NIOSH. So if any of these bodies ever list a chemical as a carcinogen or one that causes reproductive harm, it automatically gets put on the list as well. And then the formally required to be labeled products are ones, these are almost always FDA products. The ones that are required to be labeled as presenting a certain risk in this category, 1 of these 2 risks, then they'll get stuck on the list as well. So that's the 4 methods by which a chemical can be put on the list. And here is the link to look at the current list. So you can click on it when you get this. This is the dramatic and amazing thing here. 1987, 31 chemicals were either known to the state of California to be carcinogens or causing reproductive harm. Today, 2015, 911 chemicals. It's just really astounding what a bureaucracy can do when they have enough time and to do it. And that's kind of where we stand. Now, I will tell you, when I started in Los Angeles, I worked for a big firm, and this was a brand new law, and the list had first come out. And back in those days, unlike today, it was the state attorney general that was really the moving force in terms of bringing lawsuits against really large companies. So it was really the state of California squaring off against major manufacturers in the United States. And we got some of that work, and it's just fascinating because the idea, Ken Kaiser, who I quoted earlier, was sort of right in the beginning. He was right that there was a strong pushback by manufacturers and distributors to this legislation. They didn't want to put a warning label. It was new, it was scary, people would read it, and then they wouldn't buy their product, and they fought tooth and nail. The original Prop 65 battles were epic. Now you look where we are today, and they're not as epic. And the reason is there's no longer just 31 chemicals and a small number of products that are labeled. You have all kinds of products being labeled. It just gives you some feel to the reach here. You've got cheese in 1997. They went after the cheese industry because the wrappers had DEHP in it. Bottled water in 1999 because there was arsenic in some of the plastic bottles. Tuna fish. I mean, they're always going to get tuna fish, right? Ever since the 70s, I've been scared to eat tuna fish. That was before Prop 65. Chocolate, that was a great one. In 2002, Poor C's candies. Mary C's was probably rolling over in a grave on that one. French fries, they went after McDonald's and Burger King. And then grilled meat, because as you know, if you grill meat, you char it, and that causes, is allegedly a carcinogen. And then 2015, this is one of my favorites. I told my wife about this the other night. I said, you know, aloe vera is being added to the list? And she goes, like some chemical in aloe vera? I went, no, aloe vera. So be careful with your sunburns because you're going to have warning labels on your aloe vera products in California. Okay, and this is really what I was getting to, which is the warning labels have become so ubiquitous that consumers no longer really care about them or pay any attention to them. Because of that, there is less incentive for companies to reformulate their products, to make them so they don't contain the chemical in it. And what started out as a law that was to protect consumers, it was really a consumer protection statute, is now just an informed consent statute. That's really the devolution of Prop 65 over the last 30 years or so. Okay, here we have the safe harbors. And you have two basically here. You have the no significant risk levels, that's for the cancer-causing chemicals, and then the maximum allowable dose levels for chemicals causing reproductive toxicity. And here's where you can go to click on to see what those levels are. Those levels are really low, and so it's not such a great safe harbor. But I wanted to ask Natalie at this point. I mean, at ZAG, there's different ways you could attempt to determine whether your products fit into any of these categories. What do you guys typically do?
Well, so for our industry, there would be essentially two different approaches that you can take with testing. You can either do full component testing, which would usually entail throwing the product into acid, but it's going to give you all levels, right? But it kind of defeats the purpose of the law, because the intent of the law is to notify consumers regarding exposure. So the most accurate form of testing would be an exposure assessment. Exposure assessments are usually more time-consuming, they're usually more costly, but they're more accurate with regards to the law. The downside to this, though, from what we've seen is that these bounty hunters, the plaintiffs, they can bring lawsuit based on full component test results. And you could litigate the issue of exposure. You could go down that path of trying to prove, based on exposure assessment, that your products were below the safe harbor level, but the litigation is so expensive that most companies, I would guess, and I just based on our experience, you usually opt to settle. And so then you're put in a position of saying, well, then maybe we just do full component testing anyway, so and label or reformulate based on those results as opposed to the exposure assessment. So it's a tricky spot to be in, really.
And when you say full component testing, that means
it's
whether the chemical is present at all. Is that
yes, that's right. This is not very technical, but they essentially throw the whole product into acid and take the results for all chemicals based on that, as opposed to really being able to test what is the exposure of that chemical.
Right. Does anyone work with a company that does exposure testing for Prop 65, actually goes through the process of doing that? I mean, the problem with doing it, in my mind, too, is if you do it and you come back and go, okay, I'm confident that I fit within a safe harbor, and you get sued, you're still going to have to go through the whole lawsuit, right? I mean, as you know, and we'll talk about later, another one of the great things about Prop 65 is they turned legal jurisprudence on its head for the last 200 years by saying the plaintiffs don't really have to prove anything. It's really up to the company to prove that that they fall within a safe harbor or there's no exposure. So you can do it and you can come up with a result. But if the chemical is in your product, you're still going to be faced with a lawsuit and a lot of money spent trying to resolve it.
That's right.
Okay. Here's another safe harbor. I don't know how many of you deal with food products, but if it's in a food and it's naturally occurring, then it's protected. But and natural occurring means either it's a natural constituent in the food, or the chemical is present in the food as a result of accumulation or absorption of a chemical that is naturally present in the environment in which the food is grown or raised. Anyone had to deal with this before? What was your experience?
Well, we ended up settling. We had lead in a product that had natural ingredients that were, they're grown in the ground, and lead is actually in the dirt, and, it was leached into the product. Minute quantities, right? But it was enough to exceed the threshold that California provides. So, we ended up settling. I think we pursued this defense, but as she said it's so expensive to pursue. We just decided that we put the warning on practically everything we sell in California because it's on everything almost. I mean, I was in California a year ago, and it's on the entrance to Disneyland for crying out loud. So I just,
which is clearly not the happiest place on earth.
Well, I mean, are you going to stop your family as you're walking into the park? Oh no, wait, sorry.
You have to,
you can't go to Disneyland.
What was your experience with it? Have you had to be involved in any kind of litigation, or did any testing with respect to whether something was naturally occurring?
Well, we had a similar situation where we settled. It was lead and dietary supplements, and herbal products that, same thing, they were grown, least lead. But we were able to settle where, in the settlement, it set a higher level, it set what was considered for our company the naturally occurring level of lead, which actually was a fairly high level that allowed us to continue selling the product without putting a warning on anything.
Did you get a consent judgment, or did you?
Yes.
So the court was willing to sign off on that too. And did the California AG's office have anything to say about it?
They didn't object to it at all. I think we were the last ones probably to get that type of settlement. I mean, that was big. You know, that was about 2005, 2006.
Yeah, I mean, one of the real problems with this, I'm sure the next slide covers it. No, okay. One of the problems with this whole naturally occurring issue is trying to prove what the background rate is. This is not real precise chemistry. And trying to figure, okay, so you've got lead in your carrot. Carrot's growing in the ground, there's lead in the dirt. Got it, we got it. So there's lead in your carrot. But how much lead really should be in your carrot? You know, I mean, based upon the soil in which it's grown, how much should have really been absorbed? Maybe your carrot has more lead than it should have. And so you get into this, it's never easy, you know. You start getting into this circular conversation about how you can prove these things, and they're very, very difficult to prove. And again, as I was mentioning before, the burden of proof is on the company rather than the plaintiff. All the plaintiff has to do is show that there's the chemical in the product, the exposure testing kind of now he's talking about. Once that's over, then they just sit back and watch you try to figure out how to get in and fit yourself into a safe harbor. Incredibly difficult task. As this is what we were talking about. How much chemicals in the product, the amount of use or ingestion of a product daily, that's a great one because you got your lead carrot and you're trying to prove that you fall within an exception there, one of the safe harbors. The question is, how many carrots does a person eat in a day? How many carrots does a normal person eat in a day? Very difficult things. Now, who can sue? The California AG's office, a district attorney, I love that a district attorney can do it. A city attorney, this is even better, a city attorney of a city with a population exceeding 750,000. And I've noticed on my Prop 65 letters, have you ever looked at the list of recipients on the back? I mean, it's ginormous, like, you know, because they have to give every district attorney in the state of California notice. But when it comes to the city attorneys, I pay close attention to that, and there's only 4 cities, apparently, that qualify here. Surprised me. They are San Diego, LA, San Francisco, and San Jose. So those city attorneys, I've got to wonder what those city attorneys do when they get those letters. Like, great. You know, don't show me that letter. Yeah.
I just wonder if anybody's had experience with a government agency pursuing recently. I mean, I imagine it's happened, but.
You know, I only saw it back when I originally started practicing in this area when that was the expected litigation route. I haven't seen it for a long time. And I frankly haven't really seen the AG's office object to a consent decree. However, as you know, Plaintiffs' Counsel will tell you stories all the time that you have to ferret out how accurate they are about how, oh no, the AG's office is really tight on this right now, and we can't do that because the AG's office will have a real problem with it. And you go, well, can you cite me a case where the AG's office had a problem with this? And no, but our experience tells us. So you kind of rely on, a little bit on hearsay from the Plaintiffs' Counsel as to what the AG's office will permit. Nevertheless, I haven't seen any of these entities since the late 80s involved in these lawsuits. It's all, in my experience, has been private parties, otherwise known as Natalie pointed out, bounty hunters, who are bringing these cases in the public interest. Now, if a private party wants to file a Prop 65 public interest lawsuit, they must give the 60-day written notice letter. And I assume that some of you have received those letters, obviously. And the question is really, and it just tells you what the contents are. And it's silly. I mean, the statute specifies all this. You have to give us a copy of the Proposition 65 statute, describe the violation, identify the private party, identify the guy who is suing, the period of violation, the chemical, and the exposure route, how people are being exposed to the chemical. And then basically the 60-day written notice, it's kind of an odd situation because why do they even bother with this? Well, answer number one is the state wants to give public officials the opportunity to bring the lawsuit. That could theoretically happen. The AG's office could get and go, oh my gosh, this is such an important one that we need to be the ones handling it, and they can bring the lawsuit. But it also provides the violator the opportunity to cure the violation. Okay. But it's not like in a private contract, 60-day notice to cure. You know, I fixed it. Now go away. No, you don't go away because the products were still there. And so it doesn't cut off, the curing doesn't really cut off penalties. Now, again, I'll turn it to Natalie on this and say, when you get a Prop 65 letter, what do you guys do with it?
Number one, contact outside counsel.
Okay.
So a couple of things. We do use outside counsel, of course, for a lot of this litigation. The first request we have of the plaintiff is to see the test results. This isn't always a request that they're willing, to concede to,
okay.
But we would love to see those test results. It's really helpful for us as a starting point to see what they have. If we're able to get those test results, we'll usually conduct our own testing again, just to really see where we are and see what kind of negotiation room we have as far as if there's a discrepancy between the results. And then also just kind of getting a feel for the plaintiff. We've had situations where you can tell the plaintiff is very new in this industry, very new as a bounty hunter, and there might be some room to take advantage of that inexperience. And then there's the plaintiffs that are certainly very experienced, and you kind of know right up front where you're, what you're gonna be encountering as far as timeline for reformulation or labeling, but then also monetary settlements. So yeah. just to get a feel initially.
Wait, do you know, when you said plaintiff, are you referring to the plaintiff or the plaintiff's attorneys?
The plaintiff's attorneys. Okay. Yeah.
Well, the reason I ask is I would assume it would have been the attorneys, but if you've noticed, this is a big industry, as you know, plaintiff's industry, and these guys develop their specialties. One guy is like the brass knob specialist,
right.
Because brass contains lead. If you didn't know that, and you touch it, and there you go. So there are named plaintiffs who are like in tons of lead suits, so brass knob suits, and the same for plastic hoses,
Sure.
And you deal with plastic.
They find a niche and they really expose it. Yeah.
They go out there and they try to dominate their niche. So you do get to see the same players.
Yeah, absolutely. But then on the flip side of that, just recently we had an experience where we received a 60-day notice, and we did some research into the plaintiff's attorney, and he's a family law attorney, and I think he's heard that there's big money in Prop 65, so he's, making a career switch.
Well,
so it's just kind of interesting.
And the forms are available online, but it's not,
Right.
The interesting thing here is and it's interesting now that you say that you guys ask for the test results, and sometimes they give them to you and sometimes they don't.
Right.
Yeah.
Well, the inexperienced ones usually will hand them over.
No, they go, oh.
Yeah.
Okay.
So it's always worth asking, right?
The reason that's kind of an interesting issue is because they're not required to, and that's one of the most amazing things in Prop 65 is you get a certificate of merit, which is this form I've got up here, which is part of the package you get along with the statute and the letter. And the certificate of merit says, I talked to some people. What I'm saying here in this letter, I think is true. So there you go, right? But they don't have to say we did some testing, we found this present in your product. They don't have to do any of that. So they give you that letter. However, the Attorney General gets the special certificate of merit letter. He gets one that actually has the people who were consulted, because the general certificate says, well, I consulted with learned people on this. But this one, they actually get to know the people who were consulted what their experience was. And then the AG also gets the fact studies or other data regarding the exposure. So they actually get test results. And so, but those are considered to be not discoverable. I mean, I can't think of any other circumstance where somebody, the primary basis for the lawsuit never has to be disclosed to the defendant. But that is Prop 65. So that's a great idea to ask. I mean, you know, and you get the results, and most of the time it's not surprise, right. But it's still good to know what the results are. Although I will tell you that there are times when there are surprises, and that is when you buy from foreign manufacturers. And I don't need to identify any particular country or countries, but I've had clients who buy from foreign manufacturers who issue certificates say, oh yes, this product does not contain any Prop 65 chemical in it, or a specific chemical like the plasticizer phthalate, so the DHP, and they'll even every once in a while have a test, and so the client will get a Prop 65 letter, and then they'll call me and I'll go, okay, so here's what our options are. You know, it's like being a doctor here. You got three things we can do here. Two are really bad. One was probable. But they'll go, but this letter isn't right. We don't have any of that chemical in our product. Where do you get your product from? Well, I get it from this country. But I got certificates. Great. Send your product to the lab and let me know what the results are. And it comes back a few days later and they go, okay. So if you do buy your products from foreign countries, particularly ones that don't have exacting manufacturing standards, like in the U.S., you can end up being surprised from time to time.
So Brent, just really quick. So this family law attorney who's taken this career turn, he shared his test results with us, and we just had the product tested as well with Intratech, which for our industry is has a good reputation. It's a good place to go, and it came back as non-detect. So he's scrambling a little bit right now and probably regretting that he shared those results, because otherwise, we wouldn't have necessarily been able to really argue down to the details. So
no.
Anyway, just
well, there you go.
Something interesting that we're... From
now on, I'm asking for test results.
Yeah.
Although the guys I deal with are always the guys that I've dealt with like so many times.
They probably know not to.
Yeah. Okay, so we've talked about this. What do you do when you get the notice letter? And then this is really the ultimate question that you have to face. Do you fight or do you settle? And here are the considerations that you need to go through in your mind, and probably have if you've faced these in the past. One, do I fit into Prop 65's 12-month grace period? So once the chemical is listed, it doesn't immediately require labeling. You get 12 months. So if the product has been listed very recently, you're not under an obligation yet to warn. That's one thing to consider. Two, am I exempt because I have less than 10 employees? That's a great one, if it works, if you have less than 10 employees. So that's two. Is my product exempt by federal law from Prop 65 warning requirements? There's a lot of federal health warning requirements. Obviously, they don't need to label cigarettes with a Prop 65 warning. And that's because the federal government has come in and said, we preempted the field, these are the warnings that are required. And that may be true for, unfortunately, it's really not true for supplements, but it's true for some FDA products. next is, did I stop producing the product with the chemical over a year ago? And that is plaintiffs will argue with you over this, but that is what most defendants view as the statute of limitations is 1 year. So if you stop producing the product, then it has, yeah, go ahead.
On that statute of limitations, if you produce it, let's say you produced it 5 years ago, it's sitting in your warehouse in the back corner, and then the liquidator picks it up and sells it, that statute of limitations does not apply though, right?
Correct.
Because you just put it back in the marketplace.
Right.
The liquidator.
You have to basically exhaust your inventory before the statute in order to be protected. And that's kind of hard to do because there always is old stuff lying around somewhere and it gets put out. Do I want to spend the money to prove one of the safe harbors? We talked about how expensive that can be. And then, do I want to risk losing and being penalized $2,500 per day for each violation? Whatever that really means, but whatever it means, it's a lot of dough if you lose. So you know, I mean, the courts construe it differently. It's not as horrible sounding as it is, but these are all the considerations in terms of whether you should settle. Go ahead.
Sorry, can I ask one more quick question?
Yeah.
Let's say you get this letter and you're in the 60-day notice period to all the AGs. Has anybody ever tried to just pull an AG in to take over the case, just so that, because they'll be more reasonable than the trolls or the bounty hunters?
I have never even thought of that. That's an interesting question. I would think that the AG's office would be very resistant to doing that just because they don't have a real strong attitude about these cases, particularly ones brought by bounty hunters. But, you know.
But doesn't their office keep the money if they bring it in? Or
well, yeah, they don't have to
state coffer?
No, the AG, the money goes to OEHHA, the Office of Environmental Health Hazard Assessment. So that's who gets it. And it's true that they would get 100% rather than 75%, which is the de facto. So when you pay your civil penalty, and we'll get to that in a minute, you pay 25% goes to the plaintiff and 75% goes to the state. They would keep 100%, but I don't know that that would be particularly compelling to them. So, okay, here is the one that when we first read the statute, it talked about knowingly and intentionally. And there it is. No person shall knowingly and intentionally expose any individual to a chemical. So you think to yourself, hey, I didn't know. I clearly didn't have intent. This is the first I've ever heard of this. I'm safe. And unfortunately, we'll see if this even clip. No, it's not going to work. So, oh, maybe it will. This is one of my favorite movies, Whatever Happened to Baby Jane. And let's see if I have volume, but that's always something we never check. Oh. Well, no, you don't. Blanche goes, if I wasn't in this chair, you couldn't do this to me. And then Baby Jane goes, but you are in the chair, Blanche. and I can do as I damn well please. Well, that's basically Prop 65. Is you can say, hey, I didn't know I'm safe. They go, no, you're not safe. The idea here is that even if you didn't know, once you receive the letter, you know. And that counts as knowledge. So you really, the knowing and intentionally thing is completely illusory in Prop 65. Okay, now another consideration in terms of fighting or settling is whether you want to participate in a joint defense group. Has anyone ever done that before? Have you? Yeah.
Cool.
Oh, okay, there you go. If it's a new chemical, it's been listed. If it's a hot area, if it's a hot product, it'll attract attention. And if it's just starting, participating in a joint defense group where you can funnel costs and research and those types of things is actually a great way to go about it. It doesn't really happen very often, but if it does, if you discover that a lot of people are receiving the same letter as you in your industry, there's a possibility of forming a joint defense group and working the issue. Okay, now this is the other consideration. And you got two routes you can go. You can privately settle, or you can get a consent decree. You force the plaintiff to file a lawsuit, and then get a consent decree from a court or consent judgment. And Natalie, why don't you just talk us through that, what you guys do and what your thinking is?
Sure. So I think that for us, there's been a few considerations. First of all, whether we still manufacture that specific product, whether we still have inventory on hand, taking a look to see how much inventory is in channel. For us, we just wanted to evaluate that risk. You know, what is the risk that we're going to see another 60-day notice for the same product? And if the risk is low, then it's typically cheaper to settle out of court. And so we would take that route. If we still manufacture the product or we still have a lot of product in channel, then we would consider, you know, doing the consent decree and paying for that just so that we have that res judicata effect on that product.
Yeah, that's really the issue that you have to ask yourself or your attorney, which is, do I want a res judicata result so that nobody else can sue me on this, or is the possibility of me getting sued by somebody else low enough that I'm not worried about? Because there is a cost saving. It was actually primarily fees, the plaintiff's fee, attorney's fees, which you pay, because it costs the plaintiff less to do a private settlement than to file a complaint and then go through the process, the court process, long enough to get a consent judgment issued. So, but again, if you think that it's possible your product's going to be out there for a long enough period of time that somebody else is going to pick this up, then getting a consent judgment is much more protective.
But I've seen the difference to be anywhere from 15 to 30,000. Is that probably what you've seen?
Yeah, there was the low threshold or low dollar bounty hunters usually quote about. I love this, like getting your car fixed. They usually quote about 15 grand for that. So you know, I do class action defense, which is a mild subset of, and it's the crazy thing. Those cases go longer, and you fight harder. But then when the day comes, if you do settle, it's all of a sudden you're like best friends with the guy who's your client's tormentor. But in Prop 65, at least you become friends earlier in the process, and you go, okay, we want a consent judgment on this one. They go, well, that'll cost you. You know. And guys who are more on the high end will be like 30. I had one guy recently. This is my favorite moment, who demanded really, I mean, not exorbitant fees. That's the thing. They don't demand crushing fees because they can't get them approved by the court. But there are some guys who are like trying to push the envelope. And there's this guy in Pennsylvania who has an office in California too, who said, oh, you know, I'm not taking less than $55,000 for fees on this one. Right? But then you kind of go, okay, that's a lot of money. We have a lot of money in a typical Prop 65 case. By the same token, what are you going to do, right? You know. But in the end, the court wouldn't approve it, and so even though it was part of the settlement agreement, the court refused to approve it, which is kind of sweet. I didn't say anything, but anyway. So those are your two choices. Either you go for a private settlement or a consent judgment. Here are the settlement elements that you need to keep in your mind. This may be the most important slide from my presentation here. These are the things you need to keep in mind when you settle one of these cases. The products covered by the settlement agreement or the consent judgment. Warning and or product reformulation requirements. Timing for the warning and or the product reformulation. Amount of the civil penalty and how it is to be divided, 75-25. The scope of the release, particularly the downstream and upstream release, and then attorney fee payment, which must be negotiated last under ethics rules. Okay, so let's talk about covered products. Often you'll get a letter that talks about one specific product or a little product group, but you realize that your product group that has the constituent in it may be larger. And if you're going to get a consent judgment, you're going to want everything covered. So how do you go about handling that, Natalie?
Well, I certainly think there might be an option for a little bit of strategy. You know, if you are going to go down the path of consent judgment, then looking at your bill of materials and product families and different things, I think that there is a good argument to be made to include additional products if you've received a 60-day notice for maybe a specific product. So, you know, just depending, I think, on your industry, depending on what your products are like, depending on families of products, you have to really look and be able to argue that the products are similar enough to be able to include them into one, because I think there is always the risk that the Attorney General might push back if he sees that you're taking advantage of, you know.
Statute, yeah.
Yeah, right. And
right.
so I think that you have to be careful, but there might be the option to approach it that way and to try to really mitigate that risk by including additional products in the consent judgment.
Right. This will be one of the times where you want as much as you can get covered reasonably within kind of the confines of the chemical and the letter, so that you have more protection than really the plaintiff cares to give you, even.
So, Brent, just really quick, something that I might not be able to articulate because I'm just trying to still wrap my head around this. As far as expanding the consent judgment, though, to include additional chemicals, from what I'm understanding, there's not much benefit with that because of the law, you need, as a plaintiff, you have to show that there's a public benefit. If you've already got the company reformulating or labeling, then expanding the chemicals on the consent judgment isn't going to benefit you. There's the res judicata for that product, regardless of what the chemical is in the consent judgment.
That makes sense.
Does that make sense? Okay.
Yeah. Okay, I'll turn the time over to Nathan in just a second, but warnings, you negotiate your warning. I mean, the language is the language, although there are some variations to it. Interestingly, though, now, because of the new warning language that's coming out in 2018, a lot of the agreements I'm working on are ones where they look to that language, even though it's not effective yet, and Nathan will talk about that. Product reformulation, okay, I'm running out of time here. I will tell you, product reformulation, most of the time, your manufacturers, suppliers, distributors, they don't want to reformulate because it could be impossible to reformulate. Like in your supplements, I mean, you know, if there's going to be lead in them, there's going to be lead in them. I mean, it's naturally occurring, but often it's really expensive to reformulate, or there isn't really a practical way of reformulating, and so most of the time companies opt for warnings, but there'll usually be some product reformulation language in the agreement, and trying to figure out what standard you can reformulate to is kind of funny because you want to look to any federal regulation in particular that has some amount of this chemical in a product as being a threshold, and then you adopt that even though there really isn't any sense to it. And this is an example for phthalate. So the Consumer Product Safety Improvement Act in 2008, they banned 6 different plasticizers from children's products. Okay? And they came up with a 0.01% permissible amount. And that's now the de facto amount in Prop 65 reformulation settlements, even though it really came from children's products. But, you know, you got to find some standard, and that's sort of the default standard. All right, timing, this is in terms of your warning. If you have a lot of product on store shelves or in inventory, clients always worry about do they have to go back and relabel everything? Can they sell the stuff? And usually you can negotiate the timing of having the warning put on, 90 days after the effective date. Or I've used in agreements, anything that's entered the stream of commerce prior to the effective date is okay. And then you have to define what stream of commerce is. But plaintiff's lawyers will work with you, and I've never seen the AG's office care or court care as long as it's reasonable. So the idea is we got a bunch of product already made, boxed, shipped. We don't want to label it. How can we work that out? And you normally can work that out. And then the civil penalty, you negotiate that, which is how much goes to the state and how much goes to the private enforcer. And often the way I do that is I'll Google the chemical name plus Prop 65 plus the enforcer name plus his law firm, and you'll pull up a bunch of settlement agreements where you can see, it's great because when you go in to negotiate, you can see what he's agreed to in the past. They're all online, and they're on the AG's website as well. So you can look that up, and you can be armed with a lot of information when you go in. And then the release. The release is always critical. You always want to protect your downstream sellers, your distributors, your retailers. They need they need to have that release language be broad for that, to cover them. And if you sell to a big box retailer, like Walmart, or so, you will hear from them, because they always name Walmart or Bed Bath & Beyond, or Target. They'll list them on the complaint or on the letter and send them the letter, so they'll know about it, and they'll be all over you to indemnify them, typically, right? Is that your experience?
Absolutely.
And then attorney's fees need to be reasonable. Okay. This gives you a final statistic here. In 2014, this is from a Bernadette Chawla, Peter McGaugh, and Elizabeth McNulty's article. In 2014, over 1,400 60-day notices were served. Companies paid over $30 million to settle Prop 65 cases. On average, more than 70% of these dollars went to the plaintiff's firms as fees. Penalties comprise only 15% of the $30 million number, with the balance labeled as payments in lieu of penalties going to organizations that share the enforcer's perspective. But all you need to know is that of the $30 million in 2014, 70% went to the plaintiff's lawyers. Okay, Nathan, you want to take over? Oh, I'll skip that one. Oh, sorry. This is my favorite quote from OEHHA. They realize that they've created a monster now where everybody just wants to settle and stick warning labels on their stuff, right? And they also realize that that's not really helping the public interest anymore. Those warning labels are meaningless. So in 2014, this is their position. Determining anticipated levels of exposure to listed chemicals can be very complex, which we've discussed. Although a business has the burden of proving a warning is not required, you are discouraged from providing a warning that is not necessary, and instead should consider consulting a qualified professional if you believe the exposure to a listed chemical may not require a Prop 65 warning. So after creating a statute that puts every possible burden on you, and providing for discovery where you don't even get to know what their basis for the complaint is, and they make it completely, they push everything towards settlement. They go, but really we don't want you settling if you really aren't creating that level of exposure. It's amazing, this law and how the state deals with it now. Okay, you're up, Nathan. Sorry for the time.
Yeah, no problem. Guys at the back there, do you want to come and grab one of these seats? We have some chairs up here, if you want. So you're going to be able to tell from my accent as I'm talking that in the 1980s and 90s I was not in California. I was a world away. But fortunately, I'm not talking about the past of Prop 65. I'm talking about the future. And we're all experts on the future because it hasn't happened yet. So like all statutory regimes, the devil's in the details. So the statute gives the statute gives the broad brushes, and the implementing regulations give you the details. So those implementing regulations are in Title 27 of the California Code of Regulations. That's where Title 27 is where they compile the environmental protection regulations. I have some copies of the amendments to Section 25-600 through 25-607, which are the amendments that are in force now and which take effect in 2018. So just an aside on this reform process, which is taking effect next year. The genesis of that was an announcement by the Governor's Office in California in 2013. And there were two reforms that they announced. The major reform were business-friendly reforms that were going to end the shakedown lawsuit industry. They were going to cap attorney's fees, even limit and end attorney's fees. And the second focus was making Prop 65 more useful, less generic. Now, my impression from watching television is that big business always wins. And so of those two focuses, my assumption was that the big business, that the pro-business reform was the one that would actually see the light of day. That's not actually what happened, though. The changes to the that would effectively end the which required legislative changes and a lot of political will, and that never materialized. So what we're left with is mainly reforms to the right to know requirements. So that's what we'll talk about. So the question is are these reforms that will take place next year, are they a big change? The short answer is yes. If you have anything to do with labeling products that contain Prop 65 chemicals, you are going to have to make some adjustment to the labeling that previously was set in stone. If you're a retailer, in some respects, you're going to be brought into the Prop 65 party. So that's the bad news. The old labels are not going to retrofit. The only good news is if you are in the printing business, you're going to get more business. The good news for you and your clients is that there is time to adjust. The regulations will not be operative until August 30 of 2018. So there's a significant implementation lead time. The other good news is they're not designed, the regulations are not designed to be retroactive, so goods manufactured prior to the effective date in August 2018 are okay if they're compliant with the 2008 regulations. So there's no need to go through old inventory and slap on new labels. So let's turn to Natalie for a quick practice point. So without going into specifics, can you take us behind the curtain a little and let us know how ZAG is planning out implementation over the next 18 months?
Well, so to be honest, to be upfront, so we went through a big acquisition last year, and so now we have two companies who are really trying to push Prop 65 compliance. And so we're in the very early stages of doing so, knowing that we had the 2 years, now it's 20 months. We certainly have a timeline and a plan for this year, but we're in the very early stages as far as figuring out what that looks like.
And at this stage, does it look like it's going to be enough time to retrofit and get everything done?
Yes, I think so, because we went through what I considered a pretty painful process last year of implementing something, and so now just really changing our labels, because we have been testing. We have a good idea of kind of that database of what families of products contain what, and so now it's just going to be a matter of changing the wording on the labels depending on the family of products. So yeah, I do think that we're going to be able to meet that deadline.
Okay, well let's talk about some of the changes. Now, there is now a Prop 65 emoji. This is it here. The regulations state that the warning has to have and I'm quoting here, a black exclamation point and a yellow equilateral triangle with a bold black outline, which shall be placed to the left of the text of the warning and is no smaller than the height of the word warning. So that will now need to appear on your Prop 65 warnings. You also, now, someone mentioned this previously, that when you go to Disneyland, there's a Prop 65 warning, and this is one of the big criticisms of Prop 65 is that you read this warning and you're thinking, well, what chemical am I being exposed to? Where is this chemical? Am I going to die? Those are the questions. Now, one thing that they're changing is, you can see this in the middle here, you need to name one of the chemicals. And just reading here, this product, the warning should state, this product can expose you to chemicals including, and you only need to name one, you don't need to list all of them, which are known to the state of California to cause cancer, and you can do the same for reproductive harm. So a quick practice point on that, if your chemical is a carcinogen, then make sure you label it as a carcinogen because you won't get the protection if it's toxic for reproductive harm and vice versa. So that's the second reform. Your warning also has to have a link. This is bringing us into the online world. You need to provide a link to the warning that's provided by the government that is germane to the harm. So what that means is that this is the warning that you'll start to see. The one on the left is the one that you're used to seeing. The one on the right is an example of what you're going to see in the future. When to warn. Now this has changed slightly. Previously, consistent with the Act, the regulations provided that the warning was to be given prior to exposure. Now that's changed slightly now. The new warning must be provided to consumers prior to or during purchase, and they give examples in the regulations of how that can be done. You can post signs, you can do shelf tags, you can do point of display, or you can do a label on the product itself. So a quick practice point here, warnings in instructional manuals or in inserts inside a box are no longer going to meet this requirement. So again, let's turn to our expert, Natalie.
Yeah.
So ZAG is both a retailer and a manufacturer. Have you thought yet of which approach suits you better? You know, labeling on the boxes or point of display?
So our retail business is a pretty small piece of our overall business. So we're certainly taking the approach as a manufacturer, and we're doing a lot more labeling on the packaging than we are doing signage. We've considered signage for situations where, you know, in the past where we maybe didn't have a label and then we found out that we needed to have one, but going forward we'll mainly be doing the packaging on the label just because most of our business is as a manufacturer.
Okay. Okay, so this idea that the warning has to be given prior to purchase, another implication of that is that's bringing retailers into Prop 65. And we're going to do a quick, we'll do a quick breakout issue, internet sellers. So the initial passage of Prop 65 was as, did I get this right, 1985? Is that right? Did you say 1988? 86. 86. Ignore that, that's right. The new rules are intended, though, to keep pace with the shift of commerce to the online world. So the regulations define a retail seller as a person or business that sells or otherwise provides consumer products directly to consumers by any means, including via the internet. Now, under the old regs, there was a kind of a deeming provision that tried to assuage retailers that they weren't going to be, that they weren't the target here, that it's the manufacturers who were meant to provide the warning. So that's maintained in spirit, but not really in the details. Primarily, the regulations do say it's the burden of the manufacturer to provide the warnings to retailers, but now retailers have a correlative obligation, and that is the placement and maintenance of warning materials, including warnings for products sold over the internet that the retail seller receives. So a quick practice point here. If you look at that definition there, a retail seller is a person or business that sells or otherwise provides consumer products directly to consumers. You know, there are a lot of websites that are not necessarily doing the selling of the product, but they're involved in the sale. So I think there'll be an open question as to whether or not those sites are captured by Prop 65. And the question that raises also is how does that comport with the U.S. Code 47, Section 230, which is a general provision which immunizes interactive websites, and that's obviously federal law, which immunizes websites from any liability from what their people post on their website. So that's federal law. It should preempt state law, which is to the contrary. So that's an issue that we might see with internet commerce and Prop 65. The next practice point is, we have borderless online retailing. Most likely, internet retailers are not going to have a specific California website. So does that mean that these Prop 65 warnings are now going to be even more ubiquitous? Is it going to be a de facto national standard? So I have a quick question for Natalie on this, whether, when you're talking to your board and your stakeholders, do you get pushback on this idea of this California law essentially becoming a national standard for your national sales?
Sure. So I don't necessarily feel like there's been pushback from the board or the executive team. I think that as a company, we felt frustrated as far as how invasive this law is for our company, and we distribute globally, and we're making changes to our products for a California law. But to answer your question, no. But as a company as a whole, yes, there's absolutely some frustration.
And, we might see pushback on that. Maybe there might be a commerce clause type pushback where companies are objecting on constitutional grounds that this California law is affecting them in New Jersey or in other parts of the country. So I said that generally it's the manufacturer's duty to warn. Retailers, including internet retailers, only have the obligation to communicate what was communicated to them. There are exceptions though, and the first three of these are kind of common sense. Is the retail sale of the website owner's own trademark goods? Okay, well in that case, you're liable. Did you introduce the chemical to the product? I don't think a lot of retailers are actively out introducing banned chemicals to products, but if they do, they're caught. Did the retail seller cover, obscure, or alter the manufacturer's Prop 65 label? Okay, common sense. That means you're recovered now. This fourth provision, though, is interesting. If the retail seller has actual knowledge from a reliable source of the potential consumer product exposure, so first, do you have actual knowledge that there's a Prop 65 issue here? Secondly, is the manufacturer, producer, packager, importer, supplier, or distributor of the product either not covered by Prop 65, and this can occur, for example, I think we've mentioned before, if you have less than 10 employees, you're not covered, or if that company doesn't have a registered place of business in California. In either of those cases, the retailer now takes on the burden under Prop 65. Now, fortunately, a retailer can escape liability if they receive this actual knowledge by way of a 60-day notice of violation. That gives them actual knowledge. Under regulations, there's a 5-day safe harbor. They can pull the item from their shelves, or they can provide a warning. And this is a real safe harbor, unlike some of the safe harbors that we've talked about. So that is internet sellers. You have to provide it. The regulations provide you have to provide it prominently. The warning can't be in some little sub menu. It has to be effectively given during the purchase workflow.
I have a quick question.
Yes.
I work for an online retail in Abilene, and we're trying to figure out how to communicate with our vendors carefully about this issue. Sometimes it's a relatively unsophisticated industry. And I would just be curious from the manufacturers here what they'd like to see from the retailer. I mean, we have certain warnings on products on our point of sale on the specific product page, and then we're thinking about soliciting from our vendors information about the specific chemical that might create exposure under the Prop 65 regulations in 2018, but are curious what your recommendations would be to us. And we have a lot of importation from European companies that might not know about these obligations and standards, and try to build it with robust indemnification provisions and insurance obligations, but are worried.
Yeah, I think you're right to be worried because the regulations are now trying to drag you in. So I would assume, and others can correct me if I'm wrong here, that yeah, you're going to have to educate your manufacturers, because it sounds like for a lot of these guys, they're not based in California. They may have less, if they are, they may have less than 10 employees. And in that case, the regulations are trying to bring you in to fill that. Essentially, they're trying to make you fill the gap on Prop 65. Does anyone else have any other thoughts? Okay, I'm getting this signal from our marketing manager.
Do not do that signal.
So I'm going to wrap it up. My last slide is on BPA. If anyone has food issues, have food products, BPA is a big issue, and there are some new regulations that are already in force. So if that's an issue for you, you can come and talk to me. I can fill you in on that. That's it. Thank you.
We're done. Thanks.
And they also back in. I just wanted them to.
I'm not believing it.
As like a resident expert.
Oh, I would not. Kimberly, I know my covered still. Oh, wow, thanks. You know what?
How you get
Yeah, they combined all of them into one. So let's just you're up next.
I think so, yeah. So the idea is you can get from the head of the table here, okay?
So already up there. I'm gonna grab my. Here you go. Okay. So that one's there. You've concatenated them all? Yeah, they're all into one. Okay. So mine will be. That's fine. I don't know. Make sure it's there. Oh, well, I'm waiting the afternoon. You bet. And after that one then, oh, there we go. That's fine. That one. Yep. So it's all in there. I'll use this. I'll use these lights. Right. Exactly. All right. So I'm going to see here, okay? Yeah, I'm not sure. Back it up to there.
Oh wait, got the road thing. I should have done. So is this no?
Right to go forward. Okay. This one yours?
Yes, that's it.
Okay, wonderful. You're welcome.
I never done
You presented it with the analyst.
totally. This is different.
Okay, they're trying to figure out how they can get comments from anyone on some people that are watching. Okay, great, thank you.
Yeah.
That's right. Composer just last year. Israel from Jimmy Wilson. Right. I might have to reach out to you.
Okay, fair enough.
I do have your card from last time, and we're trying to figure out the new things. Some of how our impact there. You know, we're MRM, direct selling, so it's a little bit different. We do retail online. Yeah. And I'll give you mine again. So we're trying to figure out a lot of these. So go ahead and ask some questions and clarification. Yeah. Thank you. It's not going to have that much cost. I'm just going to just put a because we're not running, have a different That's what we're trying to gauge, like, hey, how do we fit? Because you're about to find out this really right.
I know. Alex texted you with this.
What time did you go?
How are you? Good. Maybe. Thank you again for being Oh, yeah. One world never seen before. I did that, right? So, I think you'll get easygoing clients I've ever had, actually. Yes. Like this one. Okay, here we go. I'm like little ADR, like stand up. What do you think? Yeah, after this, let me tell you what we should have done yesterday. Yeah. All right. Hey, we're looking forward to it. This is the best album.
So yeah, but we can probably see. Okay. Yes. Okay. It's recording. Okay. So this is the web. So I'm on one.
I'm like, hey, it's the box.
He'll like it. He'll like the idea that New Zealand goes first, right? That's the test.
Yes, I see it. I'm putting on that there. Okay, let's go up there. Stop sharing. Share again. I don't know if I can do this all day long. Oh, that's right. We'll be here. Unless it goes away after a little period of time, we just have to hover right here. Again? Okay. The chat should be here. No one can see it. But I believe it's hovering over here. You can see. Yep. So I think that's right. If you look at these and then there's also the Q&A.
I was in this building right here.
There. So I usually do it as tight as I can. But I won't see them. They'll see them here. And if we're sharing full screen, we'll see them, right? I don't think so. Okay. So this is, so we can kind of see right. Yeah. You want me to try? Pull it up full screen? Yeah, let's pull it. Are you guys right now? Yeah.
We have to put our name on the side.
Oh, yeah, that's it. I know where it's at. Was over there. Yeah, we're ready. We can go. That was a long time ago. They moved up. So can I get rid of it? Oh, they sat here and watched it.
Can I grab you anything, Kimberly, while I'm up?
I'm good. So we're going to move on to our next presenter, who is Greg Furla.
Good morning, everyone. I'm Greg Furla from Greenbridge, Oregon, Sacramento. If at any point you can't hear me, just please yell at me and let me know. I'm going to try to speak at the speaker here so the people on the webcast can hear. The idea behind my presentation is it's not a quiz, although you guys are all now Prop 65 experts after that first presentation, and so we're going to try to put some of that knowledge into practice. The idea here is for this to be interactive, so please, by all means, if you have comments or questions, raise your hand or interrupt me. The idea here is for everyone to just be in a sort of group discussion and allow us to learn from the experience of others. Okay. We're also doing this as a case study approach. We're going to go through 4 cases, assuming there's time for all 4. And for each case or company, we're going to go through specific scenarios that happen in real life. Although we are using fictional companies here, these are facts that are very similar to what happens all the time in the Prop 65 world. To get the audience participation started, can I please ask by show of hands, who here is involved in the food, beverage, or supplement industry? Okay, so it looks like about half of you. The first 3 cases are going to involve food and beverages, so these facts may be very similar to what you've seen in your own practice with your own businesses. Okay. Case number 1 is brownie and rice, and again, my company names are quite silly, but the idea here is just so that we can keep the theme, I guess. All right, Brownie and Rice is a 2016 Canadian startup with 3 employees, and they're expanding in the U.S. to both to a brick-and-mortar nutrition retailer in the United States. They make 5 brownie-flavored protein bars, including cocoa powder, rice protein, and other ingredients that their contract manufacturer assures them are standard natural ingredients. Furthermore, all of the U.S. units are going to come from a new factory, so they've hired a new contract manufacturer for the United States. For labeling, they've already got FDA-compliant labels, and they're labeling them as food. And right now, they have no Prop 65 warnings. What could go wrong? Okay, so their contract manufacturer tests their products, and all your contract manufacturers should be testing for Prop 65 chemicals, and they come back with passing test results. However, your diligent compliance officer, one of the 3 employees of this company, looks at the test results and finds that they're at a sensitivity level of 100 parts per billion. You can see the exposure calculation there, and so the first question to the audience is, just before we even dive into the exposure issues, is Bar Inc., and the retailer subject to Prop 65 at all? Anyone?
They have less than 10 employees. 10.
That's right. They have less, so Bar has less than 10 employees, so it is not subject to Prop 65. It will never face liability under Prop 65. But what about the retailer? They're a national brick and mortar retailer. Are they subject to Prop 65? Even if their manufacturer is not? I see a nodding head in the back. Well, why is that?
They're based in California, they're selling the product. They're responsible for giving the warning, right?
That's correct. So often in the supply chain, you'll have a company, one company may not be subject to Prop 65, but another company, either upstream or downstream, may be subject to the law, in which case you're going to have to look at compliance issues. So what are their options? Well, they had this really high sensitivity test, and their contract manufacturer probably didn't spend a lot of money on the testing. So one option is to just redo the testing at a lower sensitivity. And you know, what the sensitivity should be is going to depend on the product, but if it's 100 parts per billion, you're going to have to go a lot less. And most reputable certified laboratories are going to give you a sensitivity at probably around 5 parts per billion for lead. And if you ask the lab, they'll probably go even lower. Of course, they can add Prop 65 labels, even though they're not subject to the law because they're exempt with only 3 employees. Another option, and you're going to see this repeated throughout the presentation, is they could just do nothing. And this is what a lot of companies do. They just roll the dice and see what happens. You know, just because the test results are at a high sensitivity, that doesn't mean the products are actually, or that they have lead below 100 parts per billion. They could actually have no lead. We just don't know. So some companies are going to choose to just do nothing. And of course, there are risks. Okay, so here's another question. If Bar goes to market without adding any warnings, even though it thinks it might have lead in its products, is it violating FDA rules? You want to venture a guess?
Well, no.
Saul says, what's your answer, Saul?
I would say no, but that's probably just because I'm ignorant.
You're not, no, that's the right.
I just don't know any law that would violate for the FDA.
That's right. Just because you have the possibility of heavy metals in your products, that doesn't mean you're violating an FDA standard necessarily. What about a violation of its supplier agreements? Let's say this national retailer chain has I'm telling you, it's probably going to have a supplier agreement that says, you know, you must do X and certify compliance and make sure the products are safe, et cetera, et cetera. Depending on what's in that contract, there might be a violation there. Okay, be careful what you test for. So Bar goes out and it redoes the testing at a lower sensitivity. And you can see the new exposure calculation there. As a reminder, the Proposition 65 MADL, maximum allowable dose level for lead, is 0.5 micrograms per day. That is the lowest standard for lead on Earth. It's one of the most difficult standards to comply with for any company in any industry. And so you can see what their products might be, what they are testing at, 0.25 to 1.5 micrograms. So the contract manufacturer says, we can't reduce the lead, so there's no formulation option here because you're going to compromise the quality of the products. So the question becomes, is the product at 1.5 micrograms per day a certain violation of Proposition 65? Again, the maximum allowable dose level is 0.5, and they're at 1.5. And the question is this necessarily a violation of the law? Well, the answer is no, because Proposition 65 regulates exposure per day, and the regulations also provide for the MATL that exposure for some products and for some chemicals can be averaged over time. So it's probably fair to assume that people are not consuming these brownie protein bars every day over their entire lifespan. Maybe they are, maybe they aren't, but the answer is no, not necessarily, because we don't know what the frequency of use is. There's just other variables in the exposure calculation. And Proposition 65 it doesn't regulate chemical concentrations, it regulates exposure to the consumer per day. So another common question in scenarios like this is, how is my competitor selling very similar products with very similar ingredients without a warning? Anyone venture a guess? Well, they could be just doing nothing like the option was before, and just rolling the dice and seeing if a bounty hunter will catch them. Or they could have entered into a settlement with a bounty hunter that provides a naturally occurring allowance. And the most common one is the 1 microgram allowance for cocoa powder. And so if, so their competitor has been sued, they've settled, they don't actually have to get their products down to 0.5 micrograms of lead. They can go up to 1.5 if they have cocoa powder based on the naturally occurring allowance. So in some cases, your competitor might actually be better off having been sued and settled already. And so that's sometimes what happens in the market. So BAR has several options here. They can shift the liability for Prop 65 onto the contract manufacturer, possibly. Contract manufacturer is probably not going to like that, but it's something you can put in a contract. The manufacturer agrees, promises to only provide Prop 65 compliant products, and sometimes we see that, where the CMO's customer doesn't have any, well, they have liability in Prop 65, but it's going to be picked up by the contract manufacturer. Of course, they could warn, they could reformulate, and another option they have is they could change their labeling, and this goes back to the prior point about how Prop 65 is about exposure. So if people are not consuming the product every day, and there's maybe something on the label that says take 1 a week, or take once a month, or whatever the frequency is, that is a good way to argue that the product is obviously not consumed every day, and so it's not subject to that daily 0.5 extremely low lead standard. It's subject to, if it's once a week, that's 0.5 times 7, and that's 3.5. That's a much higher, sometimes easier standard to comply with. Does anyone else have any other suggestions for what BAR might do here, given that it's got these bad test results?
If it's just a bar, though, how do you know how often people will consume it, right? Because food's different, right? Not everybody eats the exact same thing every day, but a plaintiff's lawyer would probably say that, right?
Plaintiff's lawyer will say anything. But yes, they will definitely argue that your product is consumed multiple times a day. When people are awake, sleeping all the time, they will just assume the worst. And you're right, it is difficult to know often how often people are actually, consumers are actually consuming the product. This very issue actually went to the Court of Appeal about 2 or 3 years ago, and fruit juice companies argued that they weren't subject to the 0.5 micrograms per day lead standard because people don't consume the same fruit juices every day. In fact, they went using some government data and other statistical analysis. They showed that proper time period is more like 2 weeks. And so they were able to argue that they could go up to 3.5 or 7 micrograms of lead. And the Court of Appeal affirmed that decision, and it's really important case law for us now. So going back to your question, Saul, you can rely on government data, you can rely on what's on the label. There are a lot of ways to argue the point, but you're right, the plaintiffs are going to assume the worst. Okay, new company, SOS. They are Thinking Online Supplements, LLC. They're a $100 million MLM manufacturer, and they only sell through their sales reps, basically. They only fulfill the orders that their reps, the reps make. They require all their sales reps to enter into contracts that put the obligation of state law and legal compliance and regulatory compliance exclusively on the representatives. The representatives sign an agreement that say, we will provide all disclosures, all necessary legal compliance, et cetera. And they sell FDA-regulated supplements, and here's, in scenario A is their first problem. A newly listed chemical is a natural constituent of an irreplaceable fragrance additive. So there's a new chemical listing, it's definitely in their products, and they don't know what to do. First point that I'll just give you guys is that mere notice to the reps is not going to be enough to stop a lawsuit. Basically, the manufacturer, because Prop 65 is interpreted very broadly through the entire supply chain, the manufacturer is most likely going to be on the hook even though they've tried to shift the liability onto the sales rep. And if let's say the sales reps are providing Prop 65 warnings for this new chemical, the plaintiff is just going to say, well, this one sales rep that I used didn't give me a warning. And without proof of that, there's no way for the company to really verify that warnings are being provided. So here's kind of a difficult question. This newly listed chemical is a natural constituent of their fragrance additive. What do we think is the actual risk that a bounty hunter will go after this natural constituent? High? Low?
High.
You think it's high, and why is that?
Because the bounty hunter can identify that the chemical is present, or that the constituent is present, and he knows that he doesn't have to prove anything else.
That's a great point. Under Prop 65, the bounty hunters don't really have to do much work. Simply identifying that a listed chemical is in the product, or under the technical language of the statute, that there's a reasonable probability of exposure, that's enough for them to sue you. So that's a great point. If they know it's a constituent of the product, I think that creates a real risk, to be sure. But what about the fact that it's a natural constituent? Does that lower the risk at all? What do you think, sir?
Me?
Yeah.
I don't think so. I think it's a red flag to the bounty hunter to be able to pick it up.
Fair enough. So we have seen notices of violation for very similar chemicals that are natural constituents of certain additives. However, because this is a natural constituent, there is at least on its face, the naturally occurring exemption likely applies, just on the face of it, right? So even though it's true that no one is adding lead to their products, almost entirely naturally occurring, there's still a lot of litigation over that. But here we have a listing where we just know right away from the very beginning that the chemical is a natural constituent. So there is an argument that the naturally occurring exemption applies, which may encourage a bounty hunter to go after some other low-hanging fruit. The next question is, what? Absolutely.
From a practical standpoint, I'm assuming that there's sort of and maybe I'm wrong on this, but I'm assuming there's sort of a ramp-up period after something gets listed in terms of the total number of cases. Do we actually see sort of either a bell curve or does something get listed and somebody is there somebody racing to try and be the person leading the charge for that chemical? It seems like the low-hanging fruit would be let it get litigated sort of at a low level for a number of years, then after it's kind of been fleshed out, then everybody kind of rushes into the space.
I think the question was, is there a ramp-up period for newly listed chemicals? And the answer is probably yes for most new chemical listings. There's a lot of reasons for that. Part of it is, I'd say, about 50% to 75% of the plaintiff bar community is comprised of mainly people who just pick up on litigation that some of the more sophisticated groups have started. So you do see sort of a snowball effect for newly listed chemicals. At the same time, though, I could think of plenty of exceptions to that rule as well, where we see notices just scattered throughout the year. So it really does depend, but overall, I think the answer is yes. So SOS has some options here. You know, they know they have a Prop 65 issue, but, you know, they want their reps to deal with it. They could potentially beef up their contract with their reps, create some kind of compliance verification for the reps. It's probably a lot more work than they want to take on. Ultimately, probably the best option for them is just to add a warning. Of course, they could do nothing. Everyone can always do nothing, which is why we have litigation, and roll the dice and see if the bounty hunters will stay away from a chemical that is, again, on its face, a natural constituent, and thus probably maybe a more difficult case for the plaintiffs. Again, the last question is about whether we're in the clear if again, a contract manufacturer says, don't worry about Prop 65 compliance, we will cover it, we'll take care of it, and if there's any claim against you, we'll pay for it. That can't happen. All right. So SOS did nothing in this scenario, and they got sued. And now they're worried about post-settlement compliance. So they got sued, and now they settled. And their settlement, like pretty much every Prop 65 settlement, requires them to reformulate or add a warning to products sold in California or distributed for sale in California. So if they know that some rep has a customer or two in California, even if that rep is in Alaska, they still got to worry about, or the settlement is going to require them to put a warning on the product in that scenario. Of course, SOS has inventory problems. They can't really segregate by state, and of course, their reps, they don't know which state the reps are selling into. They know where the reps are located, but the reps are, you know, selling to anyone they can find. It doesn't matter what state. So this is a very difficult situation faced by a lot of companies, and there are a couple of different ways to deal with it. One possible option would be to, if the company is involved with the fulfillment process, if they have some kind of, if they're touching every single order, it is possible that they could send some electronic notice to customers who enter a California address. On the other hand, their settlement may prohibit exactly that. So it really does depend on what the settlement language is, but if they're savvy enough, they may have tried to put this provision into the agreement. They could, a risky option would be to add warnings for products for orders that are made by California-based representatives. As I just said, the risk there is that California-based rep may be selling it to, you know, again, anywhere. So it's not necessarily going to cover every sale. And by the way, you know, we've seen the plaintiffs post-settlement come back and purchase products from a different rep in the company and, you know, try to ding us for a post-settlement violation because the company was only providing warnings on California-based sales representatives. So that actually does happen. Of course, they could discontinue business with all California reps and block all California end users. That's a pretty extreme option, but as extreme as it may be, this actually might not even be enough. The reason there is because sometimes just because a California user, just because someone puts in a non-California address, that does not technically mean that they are not causing an exposure in California. Because let's say one of these end users, not a rep, but an end user, sells 50 more products to his buddies, and they find their way on Amazon for resale. So you got to make sure that when dealing with post-settlement compliance, you try to fill every crack in the supply chain there, because the plaintiffs are savvy and they'll try to exploit every crack they can find.
So Greg, how would that work? Let's say, because you've got to give a number for how many sales in your settlement, right? You got to kind of estimate, and they're going to say every sale of yours ended up on Amazon. And then how do you prove that very few ended up on Amazon?
So the question was, let's say there is a resale on Amazon and the plaintiff has found it, and they want to know how many of those products were actually sold on Amazon. The answer, there's no good answer to that because you just don't know. It's an unauthorized reseller. What can you do? You can make an argument that you're not responsible for that sale. However, the plaintiffs aren't going to care. They're going to say you should know where your products are going. And if they're ending up in California, you're responsible for it. And sure, maybe that's a legally tenuous position for them to take, but they're going to sue you anyways, knowing that it's going to cost you $50 grand to get out of that lawsuit on summary judgment. Okay, case number 3. This is Bold. They're beverage online distribution. They're a Utah beverage manufacturer with a nationwide network of distributors, including online and brick and mortar. This seemingly disgusting product that I made up is the Tea of the Sea, a 90% fish blend supplement smoothie. And they recently rolled this out to all their markets. The smoothie is sold on jungle.com, a popular online retailer that requires Bold and all its other suppliers to defend and indemnify it. So, like the diligent company that they are, they undertake a Prop 65 investigation of C of the Tea before they roll it out, and they find that there's trace lead and mercury levels, but they decided not to provide a warning, and Jungle is not providing a warning, nobody's providing a warning. So, of course, they get a notice of violation from Environment Nature Council, or ERC, an experienced bounty hunter, and ERC names both the manufacturer, Bold, and Jungle, their online retailer, presumably the retailer that sold the plaintiff the exemplar product that they tested. Okay. So, how does Bold respond to this NOV? Again, it's a scenario faced by many, many companies. Well, first, Jungle has tendered its defense of the claim under its indemnity provision, which is standard for nearly every national retailer. So the question is, does Bold actually have to respond within that 60-day period that's at the top of every notice of violation? Do they have to respond within 60 days? No guesses? Well, the answer is no. The 60-day period is actually not a deadline on the notice of violation recipient. The 60-day notice period is for the Attorney General. The Attorney General has that time to decide whether or not they want to take the case from the plaintiff. This is actually very, very rare. I'd say 99% of all notices of violation get past the 60-day review by the Attorney General. And by the way, unlike other types of civil litigation, the Attorney General doesn't actually have to issue a right to sue. If the Attorney General just does nothing, as soon as that 60-day notice period expires, the plaintiff can file a lawsuit. Okay, so responding to the NOV, Bold has several options. First, they could hire an attorney, or they couldn't. Again, they could do nothing, just ignore the notice of violation. And one option I think is important to point out here is that they can actually make a plea to the Attorney General. The Attorney General is required actually to monitor Proposition 65 enforcement. And so in the past, the AG has helped companies with notices of violation that were particularly egregious. The AG does not often step in to help companies and businesses. It's quite rare. But it is an option. If you have a really, truly egregious notice of violation that's just totally bogus, totally bogus theory from the plaintiff, it probably makes sense to run it by the Attorney General. By and large, it's not going to cost you much, and there's really no harm to just getting the AG's confidential opinion. The benefit, of course, is that the AG might step in and dismiss or pressure the plaintiff to dismiss the notice of violation or withdraw it. As always, when getting a notice of violation, the first question should be, does the statutory exemption apply? And the most common one is the 9 or fewer employee exemption. And so, sort of similar to our first case, If Bold has 9 employees, which means it's exempt from Prop 65, but the retailer has more than 10, here in this case, it's not going to matter much because Jungle has already tendered the defense of the claim to the manufacturer. So either way, they're on the hook for the litigation and responding to the NOV. Probably the most common option, common response to a notice of violation is the parties begin settlement talks. And usually that happens by executing a confidentiality agreement. In California, there is a settlement privilege which applies to communications between the parties, and which cannot be disclosed at trial if they're relating to settlement. However, most of the time the bounty hunters will require you to execute an additional agreement that makes extra commitments to confidentiality when data is exchanged early on in settlement talks. Plaintiffs may also ask you to execute tolling agreements. We are seeing a little bit less of this. For example, one very prolific bounty hunter, Environmental Research Center, has recently changed their policy about settlements. And according to multiple lawyers that work for them, their policy is now that they will not execute out-of-court settlements, and they will only engage in in-court consent judgments. And they cite the Attorney General's new regulations on how the plaintiffs get reimbursed for their fees, which are complicated, but suffice it to say, they're not going to be executing many more tolling agreements because they're just going to wait for that notice period to expire and then take you to court. Consent judgments are different from out-of-court settlements as well, and I think this topic was covered in the first presentation, so I'll go through it quickly. The main differences are up there, the 3 Cs. They are the claim coverage and preclusion, because again, you're getting a court-ordered resolution release of these claims. It's also costlier, and it's court-ordered. Other than talking settlement right away, one of the more common responses is to just begin investigating whether or not you have a defense. And that requires, usually, you have to hire an expert, hire lawyers, et cetera. It can be costly. So a lot of companies actually don't even hire a lawyer. They'll just negotiate directly with the plaintiff, Google the prior settlements, and just execute an agreement. And often that can be a totally sufficient resolution, especially if it's not a big product, or if they're discontinuing the product, or if they don't want to spend much money on the claim. Okay. So Bold, they're a brazen company, and they've ignored all their lawyers' advice, and they just ignored the notice of violation. It went into the trash file, and it sat there for months. So the plaintiff, wants to get its pound of flesh, so they file a lawsuit. The lawsuit, again, like the notice of violation, also names Jungle. And so now the manufacturer and the retailer are named in a California state lawsuit from this plaintiff. So sort of in the background of Bold, they have Jungle breathing down their neck saying, we don't want to be involved in this litigation. We're going to have to respond to discovery. We're going to have to maybe hire our own attorney, et cetera, et cetera. And Bold's PR people are saying, we have a lawsuit that says our products are unsafe. Get rid of this. We can't be marketing products that have this lawsuit. So there's a lot of pressure to settle on the company up front. Question for the audience. Does the indemnity obligation to Jungle require the manufacturer? Does it require Bold to settle right away?
I think it would depend in part on the language of the indemnification provision, but typically no.
I think that's right. The language, it will depend on the language, but by and large, the indemnity provision is not going to require the company to settle right away. It will require them to defend the company, defend Jungle, but just because they have an indemnity agreement does not mean that they immediately have to settle the case, especially if they don't think that they're actually liable. Probably they're not. Here's sort of a technical question. Can Bold remove this case to federal court? Why are you shaking your head?
Because when I came over to Overstock, that was one of the first questions I asked when I was given my Prop 65 case. And I guess because it's a state statute, or because it's a state rule anyway, the federal government will take it. According to my law.
Right, your counsel is correct. You should not try to remove your Prop 65 cases to federal court. You may actually, the judge may sanction you for this. The reason is because, and this kind of tells you something about the law generally, Article 3 of the U.S. Constitution, which empowers the federal judiciary, says the federal courts can only hear cases and controversies, which has been interpreted to mean actual cases, actual controversies. And Prop 65 allows the plaintiff to bring a lawsuit when there's no evidence whatsoever the plaintiff has been harmed in any way. Therefore, the federal courts have said, oh, this has not gone to the Court of Appeal, but we're pretty confident that most judges would see this as a case that lacks standing under Article 3, and therefore you cannot bring it into federal court. Thus, we're stuck with state court, state judges. All right, here's another very common scenario. What if Bold has an in-house toxicologist or consultant that will swear that there's no way the lead levels go above the MADL, 0.5 micrograms per day? Can Bold still be sued? Why is that?
Well, I think that anyone can bring suit regardless, right? But it's, I mean, it's the burden of proof is different for Prop 65. So the defendant has the burden of proof to show where they fall within the state.
That's spot on, absolutely. The exposure defense is actually an affirmative defense, meaning, as you just said, the defendant has the burden to prove it. So even if there's no scientific certainty, but let's say, and hypothetically there is, we are scientifically certain 100% there is no way there's an exposure above the MADL, they can still get sued. Even if you put that report in front of a plaintiff, some will say, okay, you're right, and will walk away, but probably the majority won't. They know that you have to prove this in court, and they know how expensive that is. So they're going to leverage the cost of defense to get you to settle, even if they know they're going to lose ultimately. And quite honestly, that is in the majority of cases. So just because there's a lawsuit here doesn't mean the prior options aren't available. They could still do nothing, ignore the lawsuit, take a default, and some companies actually do that. One word of caution about that is Proposition 65 is not considered a typical debt claim because it's a public, it's a enforcement action brought on behalf of the public. It has a higher status in terms of claims against a default company. Okay, so let's say, because of all the pressure to settle, they're looking at their settlement options. First and foremost, again, Prop 65 lawsuits are very expensive. So probably one of the first things Bold is going to want to do is postpone major litigation deadlines. Again, Jungle is breathing down their neck about discovery obligations. So they're going to use settlement talks as an excuse to sort of push the deadlines, discovery deadlines, case management. They're going to try to push that down the road so that they can buy some time to talk settlement, which is a good way to save money when you're already talking settlement of a lawsuit. Some advice for settlement negotiations. Prop 65 cases aren't unlike other types of civil litigation in the sense that settlement is always going to be a back and forth. You're going to have to haggle with the plaintiff. Yeah, you could look up their prior settlements and maybe they do it one way and only that way. But for most of the terms in your settlement agreement, there's going to be some back and forth, so you should be prepared to haggle. Of course, the penalties are going to be based on multiple factors. The most important factor that the plaintiff is looking at is how much money they think they can extract from you. That is pretty much their driving motivation. And secondarily, they're looking at what the cost of defense is going to be. So if they think that's going to cost $300,000 to litigate this case, even if the plaintiff knows they're going to lose, they're probably going to ask you for some fraction of that, again, to get you to settle. I think it was someone in the last presentation made a comment about how the stereotype is that the defense bar, the businesses are sort of the bully in litigation. That is absolutely not true in the Prop 65 world. The plaintiff, their burden is so low that they really don't have to spend a lot of money early on to file the lawsuit. So they can add litigation costs onto the defendant pretty quickly. So unlike John Travolta in a civil action who had to go bankrupt for, to win a case for his client, the sides are reversed here. They're going to try to add as much cost on you to leverage a settlement. And, yes, question.
Does anybody take the approach of not settling? I mean, the insurance company approach, we would rather spend the money to defend and then follow it up with a frivolous litigation claim, as just to develop a reputation of don't tread on.
In the Prop 65 world, I don't see that as much. Prop 65 litigation is just a whole nother beast. The reason is because the affirmative defenses are so difficult to prove and so expensive. So you see a lot more, I think obviously most cases settle, but the rate of settlement is even higher in the Prop 65 world. Some companies probably do take that approach, but I think I also want to say that it's very difficult to bring a counterclaim against a plaintiff, even if, again, you're 100% scientifically certain that they don't have a case. Very, very difficult to bring a counterclaim because of the litigation privilege in California and for some other reasons, anti-SLAPP, et cetera. So we don't see many counterclaims at all.
Greg, can I just add a comment here? I think for Greg, it's rare to see that draw a line in the sand. We'd rather pay lawyers $1 million to defend this than need $10,000. We actually did have a client do that this year. Greg and I took a case to trial, and that was exactly it. The client was going to settle for 30 or 40, but just said enough was enough. This was their third notice in a year, and they just refused. They went to trial, and we won. Where you do see it more often are these industry-wide cases where the balancers go after everybody making a certain type of product, and you see these joint defense groups forming and trying to defray the litigation in that way. So in that sense, you do see some folks standing up and drawing a line in the sand with that, and not using that attitude, recognizing full well they're going to spend a lot more money to litigate, but on a matter of principle, taking that as their best option.
Okay, since Bold is what it is, a very bold company, they are not going to settle. They decided that $25,000 is the most they're going to pay, which is far less than what the plaintiff wants, so they got to litigate. Step one is summary judgment, and as I articulate on the slide here, it's generally a disfavored motion for the same reasons we were just talking about. Because the primary defenses in Prop 65 are affirmative defenses, the defendant has the burden, and that means on summary judgment, where a defendant normally would be able to shift the burden to show a disputed fact on summary judgment, shift the burden to the plaintiff. There's case law in California that says that can't happen basically because it's an affirmative defense. Technically, it is still possible, but it's very, very rare. I asked the question here, can they get a motion for summary judgment even if the Attorney General opposes? Obviously, that's not good. You want the Attorney General on your side because they're required to monitor Prop 65 enforcement. However, technically, the answer is yes. Even if the AG objects, the judge can disagree with the AG and dismiss the case on summary judgment. Again, that is very rare, though. The next option that Bold has is a very, very risky maneuver, but I want to mention it anyways because it happened recently. Technically, they are permitted to file a stipulation that says, okay, plaintiff, you tested 2 of my products and we will assume that the content levels that you got are correct, and we will assume that those are violations. However, all you have is evidence of 2 violations, 2 products, because plaintiffs aren't going out there buying dozens of samples. They're buying 1 or 2. They're trying to do this on the cheap. And the argument would be, we are not liable for a lot of damages or any damages, and the plaintiff also doesn't get its attorney's fees because they haven't actually provided a public benefit because we are already in compliance. We already slapped warnings on whatever they did. A company actually did that this year to some mixed results, but it's worth mentioning because most people ask us about this. It's a very, very risky strategy, but it is technically possible. So again, Bold is, they're just, real go-getters, and they want to take this case all the way. So what does that entail? Again, affirmative defenses are your primary defenses. Basic formula for your exposure defense is right there. You have test data plus consumer data, and that's that frequency of use, frequency, amount of consumption, et cetera, plus in some cases toxicology data. Suffice it to say, there are the regulations do provide some wiggle room where the toxicology is, where there's some open questions on toxicology. In those cases, you may want to get a toxicology expert. The naturally occurring defense, which is a very, very difficult defense to prove, and again, defendants always have the burden to prove these affirmative defenses. The formula is there, and you can see there's an extra data point, which means it's going to be a costlier defense. It's test data, again, which is your content levels, plus background data, what's the actual environmental level of the chemical. Plus, you got to prove every single link in your supply chain. How do we really know that you sourced this from this area with high naturally occurring lead? You got to prove that. And then you also got to prove that through the manufacturing and processing of the product, you didn't add any of the listed chemicals. So it's a very difficult defense to prove, but again, it is possible. So there are other defenses, so I'll just mention them briefly. The plaintiff is required to file a certificate of merit before it brings the litigation, and if the certificate is invalid for any reason, the litigation is also invalid, or the lawsuit is. All right, here's a question for the audience. Remember how this product is a 90% fish blend? Disgusting, but it's also the reason why there's mercury in this product. And let's say mercury was also in the notice of violation. Let's assume there's no regulatory level, well there isn't, for mercury. There's no AUTHORITATIVE promulgated regulation saying the NSRL for mercury is X. Assuming all that is true, can Bold still present this defense at trial? Any guesses? The issue here is that the agency doesn't have an actual promulgated standard. The answer is yes. The regulations actually allow defendants to prove their own safe harbor levels. They could hire a toxicologist to come and say, the safe harbor for mercury should be X, and we're below it. So technically that is possible, even if the agency hasn't set a safe harbor standard. All right, here's another question for those with litigation experience. How many experts do you think Bold will need to hire to assert both of these defenses? Just any guess will do. 3, okay. 3, any other guesses?
5.
5 is getting close, I think. I'd go
10.
I think 10 may be overkill. I'd say probably 5, at least 5, probably 7. And I get to 7 by counting the 7 data points there in the 2 defenses. You basically need to hire an expert to prove each one of those points. Yes?
So if the defendant actually wins and proves the safe harbor level on their ingredients that the AUTHORITATIVE never set, then is it somehow adopted by California, or does it go forward for other defendants, or is it only specific to that defendant?
That's a great question. The question is, let's say the company is able to prove the safe harbor level, and even if the agency hasn't weighed in, and they prove it at trial, what is the effect on the law, and what is the effect on other companies? The answer is none. It only applies to that lawsuit. It is possible that case will go up, excuse me, that it will go up to the Court of Appeal, and not to get too technical, there is some case law that says when the Court of Appeal affirms a scientific theory, that becomes part of the law. So it is technically possible, but in the majority of cases, you win at trial, you prove your defense, it has no impact on anyone else. In fact, it's even worse than you might think. So we had a case where we went to trial, we won on these very defenses,
and then the plaintiff went out and issued the exact same notices of violation against 10 other companies, identical claims, identical chemical, nearly identical products, exact claim that they just lost at trial, but they went out and issued more notices of violation. So unfortunately, the answer is if you win at trial, typically the effect is only on the parties to that specific lawsuit. Okay, the last case, and I don't know if we have time to get through this entire case, but we are moving away from the food industry here, and we're talking about sunscreens now. So our company is CARE. They're conscientious, but they're really economical because they're struggling financially. They make mineral-based sunscreens, and they have sort of a unique advertising or marketing policy. They provide social media users with the marketing copy that they want them to disseminate on social media, and they give users rewards for referrals. So they're advertised as all natural, things you guys probably see all the time, all natural, organic, GMO-free, toxin-free, and contaminant-free. So they're just really, really conscientious company. However, they're making mineral-based sunscreens, and they have a test report from their brand new supplier that says, ooh, looks like there's a little bit of lead in your mineral-based sunscreen. Question number one, they're very conscientious. Is there an actual health risk to their 10 to 20 ppm contamination?
Under the new FDA guidance, there might be.
So the FDA very recently, I think like 2 weeks ago, issued guidance on lead levels, and I think that the level adopted by the FDA was 20 parts per million.
10.
Okay, 10. So the answer, that's the FDA's guidance on, I think, children's products.
And just cosmetics, because the background was when they did it on lipstick, so now they're saying for cosmetics, just overall, that's kind of the guidance.
Right, so the FDA has said you should probably keep your lead levels for certain products at 10 ppm or less. Now, the question here is there any possibility that the lead on this sunscreen is actually going to get absorbed into the body? I'm not a doctor, I'm not a scientist, but lead absorption is a very well-studied subject. And by and large, only a very, very small fraction of lead is absorbed through the skin. So unless you are bathing in your sunscreen on a regular basis or eating it, there's very, 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 very likely not going to be a health concern here. And by the way, lead is omnipresent. It's in nearly every natural ingredient you're going to use. So there's, again, can I tell you there's absolutely no health risk? I can't be certain, but the answer is very likely no. All right, here's the problem. This company, again, is very conscientious, but they're also very economical. So they want to do compliance on the cheap. Of course, they have marketing pressures because they're advertising their products as contaminant-free and toxin-free. But also, again, they don't want to spend a lot of money, and consultants can be expensive, as can lawyers. Question is CARE already in violation of Proposition 65 because it has some lead? Again, the answer is probably not, because Proposition 65 has a safe harbor defense for lead. That doesn't mean, of course, that they can't get sued. Any presence of lead typically is going to attract the attention of a bounty hunter. Separate question is, what about the false advertising law? They're telling people that their products are contaminant-free and toxin-free, yet they know there's lead. Any opinions? Well, that is a tough question. The false advertising law doesn't have a specification for lead. It doesn't have a specification for when a product is, there's not a lot of case law on toxin-free, contaminant-free, et cetera. So the idea here is just to raise the issue, not necessarily to give us an answer. If the company is being conservative, they're probably going to want to change their advertising, which is one of the options listed. So prophylactically, they can quietly change their ingredient supplier and try to get the lead down to, let's say, below 10 ppm, as the FDA has suggested. They can also add Prop 65 warnings. So that's not a great idea because they're already advertising that they're holding themselves out as this pure, natural company that's very healthy. They're not going to want to put Prop 65 warnings on. They could also revise their social media policy, probably something they're going to want to do. However, the question becomes, can they simultaneously, under the law, hold themselves out as toxin-free products, or making toxin-free products, and also display the new safe harbor language? Any opinions on that? Give it a try.
I would say no.
And why not?
Just because, anytime you say free, you just, I think we're going, you have to be able to prove that it's really free, right?
Right. Common sense dictates that they...
No added, it's a different language, right? Because there might be there, but we're not adding it. Anytime you use free, it's just, you're asking for it.
Real quick, there's also a legal reason why they probably shouldn't do this. Under the new safe harbor warning regulations, the agency has prohibited statements that are accompanying the warning that may contradict or otherwise dilute the message of the warning. That's actually in the new regulation, so it's possible that you'll get dinged for a faulty warning if you're diluting the message with a claim like toxin-free. Something to be aware of.
So that, just a question on that. Lead is everywhere. It's commonly known. It's grown on the ground. It's going to have lead as a contaminant. If you add language like that that says, you know, this is grown in the ground and there's lead in the ground, but here's the warning. Do you trigger that then?
Okay, so the question is, what about sort of more benign statements about, scientifically true statements about lead? Well, the Supreme Court has told you that you have a right to free speech, and that includes truthful speech. So there is a constitutional argument that, yes, if you're telling customers the truth about your products, the truth about lead, that's permissible. However, the agency is going to say, fine, say whatever you want, but you're not going to come within our safe harbor warning if you're making those statements. So it's going to depend on the language, but the agency is likely to take a contrary view. All right, the last scenario, which I'll get through as quickly as I can here. So CARE has, you know, this Prop 65 situation has just really shaken them to the core, and they're changing the entire mission of the company, and they're going to add new chemical ingredients to their sunscreens. They don't want to do mineral-based anymore. So they look out in the market and they see this ingredient that's FDA approved called octocrylene, but they also find out that octocrylene has trace amounts of benzophenone, and that this has caused a great deal of litigation already under Prop 65. They also know that as a result of this litigation, most of the industry has already settled and adopted a specific reformulation standard for chemical sunscreens. Now, other companies have done this, but CARE is brand new to this market, and they're just wondering what to do when the industry has already adopted all these specific terms. So can CARE rely on the settlements adopted by the major industry players already? The answer is probably not. Again, under Prop 65, a plaintiff can bring a lawsuit usually just if they show there's any presence of the chemical in the product. And going back to a prior question, just because the parties have settled and agreed to terms in a different case, technically the plaintiff can bring a new lawsuit and adopt a new standard for a different company. The settlement agreements, while considered de facto standards for industries, are not necessarily legally binding on companies that are new to the industry or companies that have not participated in the settlement process. So the answer is probably not. They should not rely on the already adopted settlement standards. So their options are what we've seen before, warrant for cancer. And of course, this is just a good reminder here that the company can ask its supplier or manufacturer to take on the burden of Prop 65 compliance, generally or specifically. So one thing they could do is say, hey supplier, we noticed that this chemical has caused a lot of litigation. What can you do for us? And maybe they'll say, you know what, we'll keep it below X percent or keep it below a certain level, and if that's a problem, we'll indemnify you. So that's, again, another option for the manufacturer, for our company here at CARE.
I've got a quick question on that.
Yes.
The manufacturer of the chemical, the manufacturer of the ingredient is subject to consent decree. Could that benefit a new distributor of products?
Yes and no. So it depends on what the terms are, but the question was if there's a settlement from, if your competitor has a settlement and you just...
No, the manufacturer of the chemicals.
The supplier.
The supplier upstream.
Okay, so that's, thank you for clarifying. Suppliers generally are not going to be entering into Prop 65 settlements, not because they're not subject to it, arguably they are, because they're causing an exposure in California, but because it's very difficult for the plaintiffs to identify ingredient suppliers. They can see who manufactured it, who distributed it, because that's on the label, and that's who they're going to take to court. By and large, they're not going to be able to take a supplier to court. If a supplier makes such a commitment, typically it's through some kind of supplier agreement, or the manufacturer has settled and committed itself to verify supplier compliance. And so often what happens is a manufacturer will say, look, hey supplier, we need this content level. And they'll say, okay. And then from there on out, no matter who they're selling to, the supplier just complies with that standard anyways, because they don't want to have that problem for additional customers. That's typically how it works out in practice, but the answer is, to your questions very specifically, is not necessarily. It could be beneficial, it could not be. It really depends on the situation.
So in the circumstance where I've gone back to one of my suppliers and asked for indemnification on a Prop 65 issue, and they aided in the defense and we entered into a consent judgment, they're included as a named party in the consent judgment. If they were to sell that component to another, or one of my competitors, say, that they wouldn't be able to take advantage of that same consent judgment?
That's right. The supplier, if they're party to that settlement, which again is rare, they have to, the compliance is likely to be general as to all products in that category, no matter who they're selling it to. So the answer is probably, yeah, in that case, they're going to have to comply writ large, generally, for anyone. And so whether or not that helps or hurts people is an open question, but yeah, it could have that effect. Okay, I think I'm going to wrap up. Thank you, everyone, for your participation. I very much appreciate it. And some concluding thoughts, and I don't think we have much time for questions, but I will be around if you do have specific questions. Real quick, concluding thoughts, please, Prop 65 is very difficult, but it can be made easier when companies work together. So if you do have a Prop 65 issue, reach out to your trade association. They're often on top of these issues, and typically they can help you. Formation of joint defense groups, typically the best way to address a Prop 65 case. It spreads the cost out, it spreads the liabilities out, and it can be very effective. And that's it. Thank you very much. It's been a pleasure. And again, I'll be around for questions.
As many of you can see, the lunch has not arrived, so we're going to switch presentations, if that's what you're doing.
Yeah, just send an email.
Okay, so Brent Johnson's going to come in and do the code of conduct and ethics, and then after that we'll have lunch around 12:05. Okay, and then we'll have Josh. Okay, but before we move on, let's start with
Are too kind of word for what I'm going to do. It's not just about property, it's really a larger existential question.
Dan Anderson?
Yeah. This is larger. Yeah. You did?
Mary,
hopefully you win both. Yeah. You're out of the hat now?
When's that one happening?
So my free reach out to
Jeffrey Grady?
so sorry for blowing up past few weeks. No idea. Like, is it public?
Used to be fine, yeah, they had to because they're publicly listed.
Oh.
They publicly listed. So, very common knowledge.
Okay, got it. I don't want to. So if I say I had to define pleasure sitting next to Kimberly at the council today, absolutely, I will use the word divine. Distinct would normally be, I'm taking the divine, yeah. But, throw that out, that's okay. I just want to start hitting him with so many meaningless.
I have so many people that have been trying to get more done. They all think it's very usual, and it is.
One thing I'm trying to do when there's some money to be coming from, I'm pretty anxious. We're so good at collecting, but so what it is,
I think you hear the question, so it's really good.
you manage, I appreciate you in the politics. Pain is, I mean, it's one carrier, you know, dial. Another carrier just reinforces their rate. But the challenge now is where they got to. You just get out. I find myself. If there's money to be had, Kimberly, I'm going to find it. But now the challenge is, it's between you and I. This is what I was reaching out to Damon on, was saying, hey, I really want to get those checks flowing, and I'm worried the further away we get from that coverage statement, all the way back to October. The harder it's going to be. The flip side is, I don't want board fees to charge you guys to arrange the insurance. So what I've asked is for a spreadsheet of the whole thing. What's the whole expense? Because they have to shoot me the whole expense. I'll go have a all-day powwow with the insurance carrier. We'll fight it out, and I'll at least get the cost. It would, so that is it. But in the scope of that $600 million check. Yeah, I know. So I just, with that, and then, anyway. So that's funny. There you go. Was it our fault? Did she? You try and make things pretty easy peasy. Oh my gosh, what happened? Work? The kids? It's really close to here. It's like 3,030.
The fun did not end.
So I should
No.
I'll just tell them, look. Yeah. Don, I'm talking about 3 emails in 3 weeks, so it's not going to add up.
Calamari, grill, right?
Well, the first, was trying to just catch up over the holidays, and then a couple over a few weeks. It hasn't been tested. But I'm confident now, 2 of the items is just going to execute whatever. Yeah, that is exciting. Yeah.
Okay. I think she was,
The other 2 meetings with Young Living is actually, it's like cat years. Thanks again.
is not the warehouse. Everybody are up for
The big full black one. Okay. So is it Thanksgiving in one area or? It's big, beautiful. It's right behind the warehouse. It's now at how many floors?
About 5 floors, a little large. We've only been here.
You've already filled your.
I'm already getting stuff.
Yeah, people can get put wherever they find their space, right?
Now we have, there's,
So interesting because
yes, we're all there.
so many yeah. I think we actually kind of an industrial industry. Yeah. You're employable. Highly employable. Yeah. No, I'm not kidding. Direct selling. Yeah. I was actually across the street here. It's a really nice day for what really, they're insurance and a few other nutraceutical and Tonica.
There is a fine.
Giving away the big finish might be really well everything. We love it. Their CFO I work with. And me, I'll pay for it. I'll pay for the lunch. Yeah, exactly.
Yeah, I popped up earlier and like you guys.
You didn't have to invite me.
Complain. Don't complain about outside counsel. Yeah, I work with people. I do employees. Yeah. Yeah, well, I know that
Okay. I think he had one. So for the attorneys in the room, this is I think the hour qualifies, or hopefully qualifies for ethics credit, which is always the tough one to get for continuing legal education, that we always wait till the end and then study something. And if the presentation doesn't go well, then it will also be, you'll get your substance abuse training credit as well. At least I will. Okay. Actually, the reason I say that is we switched these up. My presentation was intended to actually be more of it's kind of a roundtable discussion about some significant issues. And I kind of viewed that as being good for lunchtime, but we're going to do it now and see how it goes. Okay, a lot of what I'm going to talk about is taken from a fabulous, I mean, I will not heap praise without it really being warranted on writing, but this article is absolutely fabulous. I mean, unbelievably great writer and an incredible, thoughtful piece. And the person's name, just so you can, and the name of the publication, her name is Rebecca Kukla, K-U-K-L-A. This is printed in Health Risk in Society, Volume 12, number 4, August 2010. And the reason I'm telling you this rather than distributing the article is it's quite an expensive article to buy online, and they clearly intend to protect their copyright on it. So, but I would encourage you, I mean, it's not something that you will read and go, I've learned a lot legally, I've learned a lot in terms of procedure, but it's a great read, and it's one that makes you think deeper about Prop 65. And I will tell you that to some extent I'm a little timid in terms of talking about it because it involves mostly the reproductive and birth defect warning in Prop 65. And so, and so a lot of the attitudes and opinions expressed in it come from a feminist female perspective. And so I feel a little bit out of water. Although I did read it to my wife, and she was like, yeah! So anyway, she seemed to agree. She seemed to agree with it. Let me start off, though. Nathan, I was talking to Nathan about this article yesterday, and he had listened to a podcast that he then forwarded to me that I found fascinating and kind of dovetails a little bit into this. All of us, well, it appears that everyone here is on the younger age of the thalidomide disaster of the 60s. Most of you have an understanding of the thalidomide problems. Yeah. The podcast involves how clinical trials now in the FDA, ever since the thalidomide disaster, really exempt pregnant women from the studies. And so you will see, I mean, for those who may not be familiar with thalidomide, it was the great cure for a horrible problem during pregnancy that I've observed on numerous occasions, which is morning sickness, just debilitating, horrible morning sickness that it just always made me feel so bad. And thalidomide came along and it cured it, and it worked. It worked really well. The problem is it was imported from Europe. The FDA wasn't doing a lot of studies on it at the time, and it just got into our drug chain, supply chain, and people used it, and then just horrific birth defects resulted from thalidomide, missing arms and legs, missing internal organs, just a parade of disasters. It ultimately was banned in the United States and I'm sure everywhere else. But because of that scare, FDA drugs really are not subjected to clinical trials involving pregnant women, which results in what? Almost every drug saying if you're pregnant or nursing, consult your physician, and then the physician is expected to figure out what the issue is there. But Nathan and I were talking about it. It kind of dovetails into Prop 65, and according to Dr. Kukla's views, the problems with Prop 65 applies to reproductive harm. She points this out, firstly. Okay, here you go. We've all seen this, right? You walk into a bar, or you actually exit an airplane and walk into a jetway in California, and you're going to be greeted with this sign. You walk into a hotel or a restaurant in California, and you're going to be greeted with this sign. I mean, they might as well just start posting outside, because I'm sure the smog there is also known to the state of California to cause cancer, birth defects, or other reproductive harm. So these signs are everywhere. Where, we saw the Disneyland sign. Where is this sign located? Anybody want to hazard a guess? I mean, if you know, it's amazing, because it's everywhere. But this particular sign is posted on the door into the prenatal clinic run by the University of California at San Francisco, which is considered one of the top 5 OB/GYN departments in the entire United States. If you're a pregnant woman going in, you are greeted by this sign. What do you do? Right? What do you do? And she uses that kind of as a starting point to talk about reproductive harm as required to be disclosed in Prop 65. And she says that there are 4 problems. And I got notes here because I really don't want to do this article disservice. The first is she says that it fetishes reproductive risk. Okay. And she points out that Prop 65 applies to cancer and it applies to reproductive harm, but it doesn't apply to a myriad of other medical problems that can be caused by exposure to chemicals, particularly respiratory problems, heart problems, right? For some reason, the statute drafters thought that cancer was really important and reproductive harm was really important, but that nothing else really mattered that much in terms of warning. And she asked a question that I had never asked, even though I practiced in the area for years. Why is that the case? Why is it cancer? Okay, we get cancer. But why reproductive harm? And her point was that we as Americans are habituated to the idea that pregnant women have a distinctive and heightened responsibility for risk avoidance. That since whenever, the 60s, 50s, it has been, the onus has been put on women to be completely risk averse in their behaviors while they're pregnant, and that is an accepted part of our culture today. And she sort of questions as to whether or not that's appropriate. She cites studies, and I'm sure our European friends are happy with these, but studies that show that mild and even moderate alcohol consumption during pregnancy doesn't really pose a particular risk, or at least there's no studies that show that it poses a particular risk to fetuses. And yet, it's okay in the United States for legislatures, for administrative agencies to tell women that you should not drink at all, anything, any alcohol when you're pregnant or nursing. She goes on to say that the fundamental problem, and I'd love to get some input on this because I'm on my own here, but the fundamental problem is that it's not necessarily the case that women should live the pregnant portions of their lives trying, above all other things, to avoid any type of risk in their lives. That's sort of an unfair thing, and that Prop 65 creates an even greater degree of focus on that issue and puts shackles on pregnant women that are even beyond those that they experience in their everyday life. She actually cited, has anyone ever read, I didn't, I never read it. What to Expect When You're Expecting? Okay. Yeah. I'm sure I should have, but the onus was on my wife to be risk averse, not me. There's sort of this implied sexism of Prop 65 from this, and she quotes two provisions, actually one from the first book, which says that it's an incredible quote, every morsel you put into your body has an impact upon your baby, and that while it's likely that your baby will be born fine, which is nice to know, you should do everything possible to analyze everything you eat, every crumb that enters your mouth, so that you give your baby the best chance to succeed. And she uses that as kind of an example of how far on the spectrum we are in the United States in terms of women having to take no risks. And then apparently there's a follow-up to that book, What to Expect Before You're Expecting, which I also have read, in which they said it's never too soon, even before you get pregnant, it's never too soon to plan for that, and therefore to eat only proper foods that will nourish you and, in the future, your unborn child. So, anyway, she also points out that Prop 65 lessens human concerns about other types of health risks than cancer and reproductive harm, because it doesn't deal with them. It doesn't seem to feel that there's a warning that's required for those other types of illnesses. This is where we can kind of get into I'm going to try to dovetail this into the code of conduct portion of this discussion. Her second problem, other than fetishing reproductive risk, is locating responsibility for reproductive safety and harm. And as we talked about earlier, Prop 65, the original intent at least as expressed by Ken Kaiser and others, was it would just simply cause companies to stop using dangerous chemicals or chemicals on the Prop 65 list because they wouldn't want to post warnings. It would be just a horrible business deal for them, so they're going to stop. That was the original idea, but as you know, it really after a few short years, simply became a warning statute, informed consent statute. And I don't know, I don't think we represent Garmin, and this is not my opinion. But here is, and I checked because this article was written in 2010, and this is still up on Garmin's website as of yesterday. Okay. And this is something you all need to consider, and I'm not telling you what's right or wrong here, but she cites Garmin's statement about Prop 65 on its website, okay? And it says, a Prop 65 warning means one of two things. One, the business has evaluated the exposure and has concluded that it exceeds the no significant risk level. Or two, the business has chosen to provide a warning simply based on its knowledge about the presence of a listed chemical without attempting to evaluate the exposure. Okay? Garmin has chosen to provide a warning based on its knowledge about the presence of one or more listed chemicals without attempting to evaluate the level of exposure. With Garmin's products, the exposure may be below the Proposition 65 level of concern or could even be zero. However, out of an abundance of caution, Garmin has elected to place the Proposition 65 warning signs on its products. Any thoughts on this? I'm just curious if anybody reading this has any thoughts.
I think that's exactly the issue that we face in our manufacturer space. We sell Garmin products, and the question is, do you just blanket your entire website with these warnings so they're so ubiquitous that no one sees them anymore? Which, to your point, really downplays the risk that the carcinogens and other chemicals could pose. So it does seem problematic, but it doesn't seem like the right structure would be a really great way out.
Any other thoughts on this one? See, I have no problem with this. First time I read it, I still have no problem with it, and I think Garmin makes great products. Did you hear? Okay. But the issue to Dr. Kushka is, or I got to resume on this, I want to make sure I get it right. Kukla is this, that the company can sound almost noble with its disclaimer, when it really, what it's really saying is, we don't really care enough to figure out whether you're exposed to our chemical. We're just slapping a warning on it. And it's true. I mean, when you're faced with the choice, and even Natalie talked about this morning, we're faced with the choice of going, okay, I can do an exposure test. It costs me a fortune. It's never going to be super convincing to plants lawyers, probably, because all I have to do is show chemical in it. I can do all that, and then I can say, dang it, just like the Occupational Environmental Health Assessment, Health Hazard Assessment Office wants me to do, I'm going to take a stand here. I'm going to say there's not enough exposure, I'm below the threshold, I shouldn't have to place a warning. It costs a lot of money and the result is uncertain. Or you can say, ah, the heck with it, I don't, you know, I'm slapping a warning on it. And this is obviously what Garmin is getting at. It's like yeah, go ahead.
Well, I mean, it's what you're dealing with businesses, right?
Right.
So what's the answer for every business decision? It's a bottom line decision, typically, right?
Yeah.
How much money is it going to cost versus how much are we going to have to spend? I mean, our business, we have business in California, but not a whole lot. So, I mean, could we test and label for California-only products? Not really, not realistically from a financial standpoint. So it's easier to put a warning.
Right.
Just put a warning on it, we'll comply with the law. If somebody's really that concerned, they can ask us and we'll tell them, okay, here's what's in it. You know, here's what we understand that there's a real risk, but we have to put a warning on it.
Right. And it's completely understandable. In fact, I would probably, if asked by a client in most circumstances, I'd say, yeah, you know, clients always go, how much of a stigma is there attached to doing this? And the answer is not much anymore.
Not anymore.
Yeah.
I would just add, it's product, right? If you're selling a sprinkler valve made out of brass, it's an easy decision maybe to put a label on it. But if you're selling a makeup or something that's personally applied to someone's face or a food, that decision's not very easy at all.
No.
And it's almost impossible these days to have a situation where you immunize the warning and only have it appear in California because the bounty hunter will find a way to get that product from Pennsylvania to California. So a very difficult decision, I think.
That's actually a great point. It is true. It depends. The stigma is different depending on the type of product. It's also difficult, given the size of certain products or the way that they're presented to the public, the way they're packaged, to comply. And so there are exceptions to that, but
yeah, but those, and that's what we sell dietary supplements, right? So, and we have a California marketing office, and they're just like, we see this everywhere all the time on everything. So, just put it on. It doesn't really have an impact to the consumer anymore.
No, true. Yeah, go ahead.
I think what you're describing is sort of a flaw in regulatory practice in general, though. You know, most things start with a policy goal, which is laudable, and then they're imperfectly put into law, and then even more imperfectly, you know, realized in the real world. And so at the end of the day, you're asking, is it the business job, is it the business world's job to achieve the policy goal that started the regulatory situation? And I don't think that's ever really going to be the case. And I don't know if there's an ethical dilemma there or not, but it's just sort of a flaw. And I mean, you might say the same thing about like the Endangered Species Act, right? You know, we don't want to lose the Atlantic salmon, so let's enact this policy to save this fish that's iconic to the Pacific Northwest and, you know, a big deal worldwide. And then it ends up being the basis for, you know, stopping dam projects based on, you know, scientific evidence that's disputable. It's just regulatory policy always starts with a laudable objective and sort of ends with the devil being in the details.
I understand. I would say that the irony with Prop 65, I mean, you have lots of regulations where you say, okay, I see it's intended to do this, it seems to sort of do this sometimes. Other times it actually has downstream impacts, or impacts in other places that are worse, or in some people's minds worse than what the regulation is protecting against. This is unique almost in law because the aim that's intended by the statute is actually harmed by the statute. So it's one where the statute actually has an impact on itself and destroys, in my opinion, destroys, or in large part destroys what it was intended to protect. And her point, and I don't know that, I read her article several times, her point I don't think is she's not trying to lambast Garmin here. She's trying to point out that Garmin doing what it's entitled to do, and which is really not an ethical issue so much, is basically saying, we're giving you a warning, but we're not telling you because we don't even know necessarily what the warning really means. And yet, and the one issue she took with this notice is at the end where it says, however, out of an abundance of caution, and her point there was sometimes companies can sound noble when they're not really doing anything worthwhile. So out of abundance of caution, you could have said out of an abundance of caution and wanting to comply with the statute and not getting sued by a bounty hunter, we are providing you with this warning. But her basic point is that from an ethics perspective, and again, not a company corporate ethics perspective, but from a statutory ethics, when you provide warnings that in the end have no meaning, then you're actually behaving in an unethical manner, would be her argument. And again, I don't think she's blaming corporations. I'm just saying, she's saying when you go out there and you scare people, to the extent anyone cares anymore, and you don't really know whether or not there's a reason for them to even be concerned, then you're not engaged in what she, as an ethics professor at Georgetown University, believes is an ethical course of conduct.
Well, someone's being unethical. Is it the California state government that's created this monster, or is it the businesses that are just trying to comply and survive?
I think she comes down on the side of the California legislature as being, I mean, she doesn't say that precisely, but her focus is on the statute. This is simply an example of how businesses go about trying to deal with it. But I think her fundamental notion is giving people contentless warnings, but in particular, giving pregnant women who are already told by media, by everybody, by everything in our country, that they should avoid every possible risk that they can ever avoid, they should do it. And then going out there and saying, and by the way, there's 911 risks, and you will see them whenever you walk into a restaurant, I mean, in California, whenever you walk into the subway in Long Beach, you'll see a warning. And what are you supposed to do about it? What is the message that's being conveyed to the pregnant woman? So that is, that's that point. And then finally, and this gets right back into her third point is, she calls it the myth of informed choice, which is really what this is. It's not a reality of informed choice. It's simply a myth of informed choice. And her fundamental point here is what we've talked about, the signs, the warning signs, often straightforwardly misinformed. These warning signs in her mind are often misinformation, not information. As we know, as we've talked about it, the signs don't measure a risk. They don't say, here, in our normal lives, if we're going to take a risk of some kind, at least we try to do some gut level check, say, I got some data here. I know that having a drink and driving causes accidents. I've seen reports. I know that I have some data point to make a decision on. But here, there's absolutely no data for the pregnant woman, to make a decision.
Presumably the 2018 statute addresses this, right, by having a required disclosure of chemicals?
I don't think so. And that's, to me, I can't wait to see them, because if they say this product contains DEHP, which is known by this, if they start using chemical names like DEHP and that, which I think they will, I don't know that that provides any more information unless somebody pulls out their smartphone and Googles it.
If I understand correctly, you're only required to disclose one of the chemicals present, so you can have
each of the categories.
One each of the if you have chemicals in each category, yeah.
Maybe we add the less bad ones in.
Right.
Yeah, I mean,
The more unfamiliar.
You can see the more complicated name. I like the Pele name. You know, first of all, it's got a T in there, which I have no idea where it is.
Oh, yeah.
But I mean, there's any number of chemical names that can be used that aren't going to provide any additional information to anybody who's reading the sign, right? So, but it clearly, and I saw this as a flaw in the statute initially too, which is all you have to do is say it contains a chemical. And since nobody knows what the chemical is, how significant is that? Now they're going to have a chemical name, and I get why they're doing it, but I just don't think it impacts the warning, particularly when it's 911 of them that they can choose from.
Brent,
yeah.
I do think it forces companies to a certain extent to test the product at least. Like you've got to at least have some information, right, before you can do the labels, whereas before you could just slap the label on. So there's probably a little bit of control there.
Yeah, I think so. I mean, yeah, I think it's always should have been the case that companies test their products at least to determine what chemicals are in them.
In theory, but I think the result was sometimes that you got to the point where you said, oh, I'm just going to put a label on it.
Yeah, there's a likelihood that there's something in there. What the heck,
right.
You know? So her point here is that there is no informed choice by this statute. They don't say what the chemicals are, although that will change. They don't say at what levels that will not change. So there's no concentration level requirement. And it doesn't actually say with any specificity what sorts of risks the chemicals pose. So in her opinion, and I have to agree with it, the warnings provide neither the quantitative nor qualitative information needed for a cost-benefit analysis. The same kind of cost-benefit analysis we do every day. And then she circles back to her main point, which is, why would the state of California do that? Why would they think that was acceptable to do in the first place? And the answer, at least with respect to reproductive harm, is that, in her mind, the attitude was, who cares? Women are supposed to be 100% risk averse anyway. Right? Then she also finally talks about, and this is the point about the subways and the restaurants. Her final point is that it harms pregnant women materially because it affects, to the extent they take these warnings seriously, it affects their ability to participate in life. You can't ride a subway because you're concerned about reproductive harm, and you can't eat in a restaurant because you're concerned about reproductive harm, or you can't use certain cosmetics or soaps because you're worried about reproductive harm, then it significantly impacts the pregnant woman's ability to participate in daily life. And she views that as an incredible negative. So, any thoughts on that? I mean, I don't know if I'm preaching to the choir here, but I always looked at Prop 65 as a nuisance and a trap as a lawyer, right? And that's kind of how we look at it. Oh my gosh, seriously, we have to do that? Or, oh, busted, I got to figure out how to get out of this one. I mean, and that's kind of what it is. But when this ethics professor comes along and writes this article, and you realize that actually it's a lot more than just a gotcha trap. It has, to the extent that anybody, including pregnant women, take this seriously, it's an has an incredibly negative impact on their lives. All right, now we'll move on to ethics, codes of ethics. And I'm going to almost turn the time over to Natalie to talk about this. This is, well, no, I wonder what Zag does. I mean, this is how you deal with your distribution channels, how you deal with your suppliers, how you formulate codes of conduct or codes of ethics. Do you feel, with that broad of a question, you can go for it and tell me how Zag does it?
Well, so those are kind of two different approaches, right?
Right.
So we've got the supplier approach, which That has been certainly a focus this past year where we've tried to implement the language in our supplier agreement. Dave, one of my colleagues, he's actually been focusing specifically on that language in the supplier agreement. So if it's okay with you, I'll have him speak to that just for a minute, and then I can speak more to the distribution side.
Okay. I mean, I think ZAG has had language to try to wrap in a variety of different matters of conduct, and I don't know whether you want to discuss ethics as well, but I guess they do qualify, that I think many people would be familiar with in terms of, for example, conflict minerals, compliance with international environmental regulations or requirements, blanking on it with another California regulation with
the Supply Chains Act.
The Supply Chains Act. And so we have had, and these have evolved over time, requirements that suppliers be certifying that they're complying with these various things. And then most recently, we've actually been including specific Prop 65 language in there saying you understand, agree to comply with Prop 65 in terms of certifying what's in your product. That's daunting, but I'm not sure how else you go about doing it. It's as you're talking about sort of ethical implications that this professor's raising. It's totally unfeasible for a manufacturer to say, I'm going to do my own independent scientific review of the literature out there on all 911 of these, and I'm going to include as a package attachment something that assesses what ZAG's interpretation of the likelihood of carcinogenic risk is for somebody using our product. Is totally unfeasible, and will be totally useless to a consumer. So we obviously are including, to the extent that I think we can, that and calling it out specifically beyond just saying you will comply, you agree to comply with applicable laws and regulations, but actually calling out some of these higher profile ones, and Prop 65 is to that point where we are calling it as a specific regulation that we expect suppliers to comply with.
Yeah, I've wondered, I mean, I've very recently seen specific Prop 65 certifications. I think not too long ago, it was just the standard that you said you comply with all applicable federal, state, international laws if you're, you know, but you're now calling Prop 65 out separately on that. Yeah. What do you, from suppliers, what do you do? I mean, there are a lot of products, and that it's hard to be completely free of a chemical, right? On a listed chemical. How do they certify? And do they certify that they've told you if there's a chemical, or what? How do you handle that?
Well, I can speak to that a little bit because this last year, as we've gone through this process, we had some documentation showing that they had already certified to some extent, but we're finding maybe a discrepancy in, you know, a lot of our factories are in China. Some are in the U.S., but a lot are in China, and we're finding that there's a discrepancy as far as maybe their understanding of what that means. And so it's really a collection, you know, that we have to do as far as getting the raw materials list and doing our own evaluation here in the U.S. and having a U.S. company help us with those risk and exposure evaluations. So whether this language is actually going to help us, well, I think the language is just kind of the tip of the iceberg, let me say it that way, that we're still going to have to test in the U.S., we're still going to have to do a lot of due diligence here because of the discrepancy maybe with knowledge as far as what the law really means.
Well, it's also problematic to say our supplier looked at the product that we want to make, they went out and sourced it, and they're going to continue to maintain the same sources for all their materials for the entire product run. It's just totally unrealistic, I think. But by creating that code of conduct or the standards that we expect them to comply with, it's at least a starting point, I think, for trying to bolster from that end of things.
Yeah, it seems to me that, and I never get called in at this really interesting portion of the manufacturer's process. I'd be fascinated to be involved in it one time. So I'm always in when you get the letter and you go, okay, that's fine. But in the process, do you ask other than the certification, which you don't require a certification on a yearly basis, or do you? You don't? No.
Well, we will, specifically with Prop 65, but we have in the past just as a more of a general certification, right? Okay. But that's where we're finding that there was probably a discrepancy with their knowledge, because they did certify that it was compliant, but we're finding that that isn't the case.
Right. And do you ask for lab results ever?
Yes.
You do? Okay. I'm sorry, I don't want to make you uncomfortable. Those are questions you want. But I mean, we all know that in the end it doesn't really protect you because the statute doesn't care. It pretends like it cares about your intent and your knowledge. It doesn't really care that much about it. So it's more of a just simply a way to protect yourselves to the extent possible, right? So you do ask for lab results. Sometimes you ask for a certification that may be updated. And it's true that, I mean, when I represent manufacturers and other kind of lawsuits, like when batteries explode, you always discover that the manufacturer in China or wherever has changed sourcing from stuff. And they do it all the time. It's okay. I mean, that's part of their business. But since Prop 65 is not top of mind to them or anywhere near the top of mind to them, it's not like they're worried a lot about it.
So with a lot of the supplier issues, and Prop 65 might be a little bit harder to see into because you've got the component parts coming from all over the place. But it's important to get your own people from the state in those factories on a regular and consistent basis. And so with a lot of our code of ethics policies that are part of our supply agreements, we do train our teams that are in those factories most frequently on what to watch for. And some things, are really easy to watch for, right? If you watch for child labor, you can kind of spot that out. And if you're over there often enough, you can see if there's an abuse. Prop 65 is a little bit harder to spot if there's a violation and you're being lied to by your supplier. But as you know, we try to have these monthly meetings with our team here in the States on Prop 65 and educate them. And over time, I think that they become more familiar with the issues and to what to watch for. And if we've specifically said this particular chemical is a concern, then they know to watch for that one, and they just are more aware when they're in those factories.
So do you in your supplier agreements, do you have like an audit provision or an inspection provision?
We do.
Okay. And do you like have a programmed time when you do it, or do you do it as you can or as needed, or?
The audit provision would allow us to go in, I think, once a year is what it is. Now, we're probably not as good at that as we should be, something to work towards, and I think we're getting better. We're certainly doing far more than we were if you'd asked us this question a year, 2 years ago. We're getting better and better. But honestly, we probably have our people from the United States in those factories at least every 60 days.
Wow, fabulous.
So there's another California law that has some disclosure requirements that kind of motivates the manufacturer to be in their auditing, and that's the California Transparency and Supply Chains Act.
And that deals with you go ahead and tell us some.
Yeah, so it deals with the audits and those types of things. So, of course, though, another California law is pushing us and parenting us.
You know, it's funny, not to get too far off topic, but California has a long and treasured history of being able to be the tail wagging the dog in terms of regulatory regulations. I mean, California is such a large state, and saying I'm not going to do business there is so suicidal that people do business there, and they have to put up with stuff that they would otherwise not have to put up with. But that ultimately becomes a de facto standard, national standard. I still do made in the USA class actions in California. You know, they changed the law finally, but it's still pretty bad. In the old days, 100% of your product had to be, and all the components had to be made in the USA. And I have companies that are so proud that they've looked at the FTC regulations, they know what the Federal Trade Commission requires. They're like 95% domestically sourced, which is amazing. But there are certain wires you can't buy in the U.S. because nobody has enough, I mean, you can't make enough money in the U.S. making them, right? And then they'll get nailed with a Made in the USA action. And so that becomes, California's Made in USA statute becomes the de facto national standard. It's frustrating. Ironically and probably humorously, Vermont, a couple years ago, maybe 4 years ago, they tried to get in the game with their GMO laws. I don't know if you guys have to worry about those, but I also do GMO work. And they came up with this incredible statute requiring disclosure of GMOs in any product, right? And if you read the bill, which I did, the preamble is all about how the federal government has really fallen down on this, and that Vermont has to come in and take up the cudgel and teach us all how to make sure that we disclose GMO in our products, right? If California had done that, I don't know what the congressional response would have done, but like within a year later, which is lightning fast for Congress, there's the new law, the federal GMO law. This is a silly law too. I guess you can scan with your iPhone and see if there's GMOs in your product. But they got involved and they said, we're done with Vermont. We don't like your law, and we're not going to make the rest of the country follow it. California, on the other hand, always sort of gets a free ride on that stuff. They can do what they want. But anyway. What do you do? Tell me about your relationship with your downstream and how that works on Prop 65.
Sure. So there's those agreements. Well, maybe half and half are the distributor or the retailer's agreement. On the supplier side, it's usually our agreement, and there's usually pretty robust indemnification provisions in there that protect them. But it's interesting, you know, as these new regulations pass, that they will probably see more pressure from them, I would guess, as they become more involved in, you know, more they carry more of that risk a little bit.
Do they I've seen some of the big box retailers indemnity agreements, because I'll get them sent to me. I think as we talked about before, the plaintiff lawyers know how to leverage you. They know in the end, you, the manufacturer, are going to be the one that's on the hook for this. But one of the nice, easy ways to get leverage on you is simply to name one or two of your retailers, the big ones, you know, and when they do, you get a phone call immediately from those guys saying, you got this, right? You got our back on this. And it's funny because they include all these indemnity provisions in their agreements, but by and large, even in the absence of an indemnity agreement, if your retail channels are Walmart or someone like that, you're going to do whatever it takes to make sure that they're covered.
That's right.
Right. So it's nice that they do that, but I don't think they have to worry that much about it. Do they identify Prop 65? I've not seen one that says.
I haven't seen one. Have you seen Prop 65 called out in distribution or retailer agreement?
Oh yeah, definitely.
Oh yeah, yeah.
Okay.
We recently had one come in, and they wanted us to provide Prop 65 indemnification, and it was the first time though
that was a separate agreement, right? It wasn't.
I can't remember which one it was, but they had asked us to indemnify. Yeah. We were a little bit uncomfortable getting that indemnification, knowing that we were kind of in the middle of Prop 65 case, you know. Yeah. So, but it was the first time that I had seen it come up. Yeah. In memory that I had seen a specific request for that from one of our.
But our customers certainly reach out and just want confirmation, want that validation that we are providing that indemnification, that we're going to take care of it.
Yeah, I've seen, it's kind of I won't say a wide range, but there's sort of two ends of the spectrum. In my experience, most of the retailers, when they notify you guys, and you come back with a letter that says, don't worry, sleep well, we'll get this fixed.
Right.
Then they just kind of dissolve into the ether. They don't, you know, they got you. But there's a few of them who will remain nameless, who have these like outside lawyers who, while they don't interfere with your case, because they don't really want to, there's no point in doing that. They'll like call you up monthly or ask for a status report, and you're writing status reports. This month, nothing at all happened. You know, next month, we talked preliminary. You know, it's one of those things where And I've seen at the end of these lawsuits, all of a sudden you'll get an invoice from this law firm saying, pursuant to your agreement to indemnify us, you got to cover the fees. And you went, wow. and we do, but not the law firm. But but I would say most of the retailers that I see are generally just want confirmation that you got it covered, right? Yeah. That's about all I got for this presentation. Anybody have any questions at all about? I mean, we have all the Prop 64.5 lawyers in here right now. Anybody got any questions or concerns that we haven't addressed? I turn it over to you.
Okay, well, we'll do a really quick drawing, and then the lunch is actually set up outside. Thank you very much, guys.
Good job, Brett. I'm a better person now.
You're more ethical? That's good.
I feel like I have a more rectitude, like a compass.
Yeah.
Yeah.
Yeah, I'm sure you do. If you don't call them back, I'm going to flip our hours.
Speaking of labeling, that's rock solid. With yourself, shut down your pacemaker. That's great.
We always welcome the education.
If anyone, if in the next 10 minutes, get up, take a break, grab your lunch, come back.
I'm actually on the I'll kind of wait for your cue and then but it's not very long.
Okay. Like 30 minutes.
And just curiosity, yeah. There's just actually not that much.
Okay.
Truly. Well, it's a factor, but yeah, we'll get into it. Yeah, exactly. I'll wait for you. Look at that right there. So Zach, fully represented. Slim book. I got like 50 of them. They're the best.
So familiar to me.
I'm Josh from Trustco.
Did you go to the University of Utah?
I did.
What year did you graduate?
But I wasn't very, involved.
What year did you graduate?
Well, I took the long route, 2004.
Oh, okay.
Yeah.
Well, you were familiar then. I thought for sure we went to school together.
Probably just some, actor, male model.
That's got to be it.
Yeah, sure. Honestly, though, I do love the product.
Oh, good.
Yeah, it's
awesome.
I think I will be 20.
A good solid half hour to just network.
Yeah, but over here, probably gonna have pretty much. Okay, so should we plan on? Awesome. Yeah, at this point, tell me, get going, man. Yeah, for sure. Yeah. I think I'm not that, like, 150% spots and, like,
you all teed up, okay?
Am I after one?
No, I'm sorry you're not. I'm getting Josh teed up.
You're getting
Right.
Josh teed up.
I'm gonna really lower the bar though, so almost anything you do is gonna sound awesome. That'll be great.
Thank you. Take one mute during your. Like 3, 2.
I turned yours,
Yeah, we do. Oh, good.
and after this is also talking to ask.
Okay.
Because really the only way to talk to
Take your break off. Sorry about that. Well, it's better than getting
Sarah's trying to make sure it's national, but because
That's great.
trying to catch up.
Exactly. We have a lot of
If you're interested in this, and I'll again.
show that we're I just know that I get
You see a law firm river flood, and then.
So you're got it. But you do three things. No, she's great. Yeah, there's a very different which I found fascinating.
Have a hard time. So I'm love you.
That's a great thing. Yeah.
So they need to know.
So, the weather probably not.
The screen, when I'm logged into the web, I feel like the screen was kind of like black, but it didn't look like it.
Start sharing again. Good, we're still in it. Looks like. Still recording. And we're called up. We just need to go back to that one. We're not in it anymore.
I didn't run in the PowerPoint.
Oh, there we go.
Oh, that is it.
Oh boy. Oh, the second cup. And then we got share here. Yep. Okay, good. It didn't drop.
Yay, that's very
Back to normal.
I should have mentioned my laptop was getting ready to start, and I said bring my charger up. I should have known it would get lost. Oh wait, what did I just do?
Share it again. Sharing anymore. You can go back.
Get some lunch. So what is the general kind of response? How are people feeling?
It's tough.
I just don't see how. I mean, you're what?
No, you
Kimberly, and
that's
what Kimberly is what, or what?
messing it up because you bounced out of the PowerPoint. You bounced out of the show.
Right.
So it's no longer shown.
I mean, it's fun. Can I go to a different
Well, I mean, Josh hasn't, but other than that.
You know, I can hear it. I'm just going to go up. Okay, I got it.
Oh, wow, then I might not. The only area would be like directors and officers coverage, you know, but I mean, in my world, the only thing that's permanent is impermanent, so I'm just not so stressed.
Clicking it, right?
It's great for Unique, it's great for me, and I like it. I'm not. Maybe I've just see the chaos so constantly that it's easy to have an impact.
Really random, reference that,
Yeah.
Started?
No.
Actually a fantastic answer. So he's always like trying to thank you.
Right before. Right.
Work on your sales.
Fantastic. Meant for life insurance, that would be great.
Anyway,
well, I'm excited for you. It'll probably mean a lot more. I know Unique already has a lot of resources, but more.
Yeah.
You know. But I have seen cases where companies that are that huge do buy it as an asset, plug it into their chain, and let it run itself. Especially when it's doing so well. They made a move. Then they're looking at cut. Yeah. Great. That means more apologetic budgetary emails from Josh. Dear Jamin, I tried to project. I tried. But Reggie and I come from a long tradition of kind of under-projecting, and then how product liability works, well, insurance is based on revenue, and then they true it up. So Reggie and I come in place under-project, and then when the true-up comes, you kind of negotiate and work. And we had a lot of success with it. It saved a lot of money. So, anyway,
I've just never dealt with someone whose revenue is, like, right when you think, okay, it's going to plateau a little, it's just this, right? Yeah, it's insane. Anyway. So were you on outside counsel before me?
I started my career I was with a firm. It kind of went in house. It was more like a, like I was managing a really small company. And then my parents were like, look at everything. I came back kicking and screaming and going back to a firm.
Really?
I don't know. I think I'm like the uber responsible parent. Like I'm always going to be the one that's like working later.
Right. Well, and firms will just let you work yourself to death.
Oh, yeah.
Yeah. No, gladly accept that. Did you grow up here then? All right. Whereabouts? Sandy, nice. Alta. Yep, grew up, holiday, went to the U, got married super quickly, dove into insurance as a just something to kind of experience. Actually, I was just going to do it temporarily while my internship years at Dean Zitter paid off, but just fell in love with it. Literally, I don't know how to say it. It's embarrassing. Yeah. You get to work with a lot of companies, see how they do what they do. You know, just play a tiny little role in it. And then they want me on real. Pretty soon, I think. Right now, you're the sole recipient of all the payment. Yeah, sure. So when you went to LA, were you married? Okay, that would be fun. Like, having a family. Really? Come on, we're doing okay. Do you live up here? Do you live in?
I live in downtown. Everything closes at 10 o'clock.
Yeah, that is a joke.
And everything's geared towards
yeah. But isn't it churning a little bit?
Being able to go.
Yeah. Yeah.
I can go.
Yeah. It's an okay thing. I mean, I love my kids. That's okay. Yeah, I'm kind of a night owl. The restaurant hours drive me. Yeah. It's the problem. Funny you said I was in Washington, D.C. last year, and every night, 2 in the morning, I was at a Thai restaurant. Almost getting killed on the way there, but just loved it. So, yeah. Be tough to have a family. Yeah.
Those are a little bit farther out the city.
Yeah. We lived down here for a couple of years. My wife and I lived at Gateway when it was first. Well, and that was pretty fun.
She works for Ernst & Young.
Okay.
And they're located in the Gateway.
Right.
Across from the road. They're finally getting out of their lease and moving.
Every night. Because I was on the furthest. My apartment was what would be the southwest corner. So I had a beautiful view of the homeless shelter every night. So my dining room was just blue and red from the windows from the siren. Yeah.
They have this what baby
Clients don't love to watch it.
That's nice to do a quick track.
Man, I've seen two client restaurants go in and out of business right there. Promised that they were going to move it. You know, that they were going to move the homeless shelter. When they drove in, didn't happen. Just went out. Two really good sushi restaurants. Yeah, it's a mess. It's a problem, and you want to be really sensitive to the plight of those people. At the same time, you know, it's really bad for business. Yeah. Mm-hmm. Yeah. Sure. Yeah, where did the entitlement come from? Yeah, I don't know. Yeah, I was going to say that might be one step beyond rational. So did you go to law school down there? No. Okay. Nice. It's a great law school.
Yeah. I used to go back to school. We've done that area.
Yeah. Provost, actually. Being a U guy, I get it. My buddies who went down there had a blast. Yeah. Yep. Yeah, that was all I did was commute. I was barely there. Mm-hmm. Yeah, so Matt and Reggie were my first two sort of bosses over there. And then it shifted to Chris. You know, infamous Chris. Mm-hmm. And then Jamin. I know why you're a rock star.
But I met
Oh, he's a great guy. I'm so bummed about the fallout. I mean, I understand it. In my business, it happens every time. An agent leaves his office, eventually more into stuff. But yeah, we have a lot of and when it first happened, you know, he was talking to Reggie, he was like, yeah, I'm sure he'll reach out to you. I think network marketing business. So he did, but about the second I heard what was going on, I put an end to that. Yeah. Well, I knew I was going to be involved in campaign, right? And I've been down that road before where I'm the guy on both sides. I mean, it works because I'm not the insurer and I'm not the counsel, but it's too complex. Nice. You know, we certainly maintain our friendship without me writing his insurance. Believe it or not, this is possible.
It is.
Where are your offices located?
We're currently in Brigham City, but we're in the process of building a home facility in August. We'll be moving on.
Up there. Kind of a drive down here.
A little bit of a drive. So.
Got chocolate.com.
Actually, I live in Bountiful. So.
That's perfect. My general counsel is in Bountiful. You work in Lehigh.
Yeah, that's their own direction.
He's really glad you're free at night.
I have it in the right direction.
Well, Wayne drove down for my presentation, right? So it's about to be worth it.
That's right.
Yeah. Like,
I'm looking forward to this.
Yeah.
This whole Prop 65 thing. So this is quite an eye opener. So.
I live in California, so that's how I know about it. But
Well, about 80% of our business is in Southern California, so we're fairly exposed.
Who are you with, Wayne?
Companies called Honeyville, food, co-packer largely. A lot of the products. You'll go into Costco and buy a pancake mix.
Yep. Right. Cool. Okay. I'm going to go see if they want me to start pouring everybody to sleep.
Which direction do you have it right?
I live downtown, but I work in Lehigh. But having lived in Los Angeles, I don't care about them.
What part of LA were you in?
I was in Moscow for a little bit, and then I went back to New York.
All our operations are out of the Inland Empire, the Ontario ranches. Quite a place.
All right.
Travel there a lot?
I'm down there about monthly. I'm there.
Things get rough. Someone pulls fire.
We're loving it. Yeah. Insurance side you get to talk about, huh?
Yeah, what there is of it, what there is to offer. Yeah. This is my kind of remote. 2 buttons. All right. Hard to mess that up. Unfortunately, I got this Zach Prop with separate. Set this over here. That's out of my way now. I really do love it. All right. Allison, do you want me to just launch into it, or? Okay. Fantastic. Well, it is a privilege to be here and to corrupt your lunch hour with some insurance discussions, insurance-related discussions. I'm Josh Whitwer. I'm with Trustco. Let's see what we got here. Okay. All right. Quick warning. My marketing team, we just hired this hotshot out of college who was just insistent that all my slides spin and whirl and drop. And I just didn't have the heart to tell him yet, you know, give yourself a couple of years in insurance. You realize there is no glamour. Just get in the game and accept it for what it is. But yeah, it's funny, this Disneyland deal has come up a few times. This was one of my first introductions to, well, I've seen it in a lot of different products, but this just made me laugh. And of course, I told my daughters, who were 7 and 4 at the time, that we got to get out of here. You know, Cinderella and Belle, little redhead's not going to happen. Speaking of my daughters, so Scarlett, my 10-year-old, this morning I was getting ready to head out. I was totally ready, briefcase, and she was kind of conscientiously sipping her smoothie. And I said, hey, wish me luck today. And she said, well, what are you doing? And I told her I got to go to this fancy law firm downtown and talk to these people about something they likely don't want to hear about. And she said, well, you really need to lose the beard. I'm leaving. I had my briefcase in my hand. So anyway, Kate's got a great beard. Renat has a great beard. My beard apparently is not great. Okay. So I thought it might be helpful to kind of dive into what impact insurance has or can have with respect to Prop 65 by doing an overview of the commercial general liability program, or, you know, the key types of policies that may or may not respond. And I'm just going to come right out in front and say insurance is not the solution. It can have some impact, it can have some use, but that's not why I'm here today, is to tell you that insurance will solve all of your Prop 65 concerns. Marketing. Let's just get to it. All right. When we
when claims come, letters come, lawsuits come, right, and the insurance broker and the carriers get involved, right, it's important to bear in mind what they're usually looking for. You know, sudden and accidental loss, that's number one. That deals a lot with property, but also with some liability cases. Legal fallout from negligence, and most commonly requiring bodily injury and property damage. This is really important. Super simple to a room full of people that are this smart. But know that the first thing they're looking for in any claim, particularly if it's your general liability program, is there any bodily injury, is there any property damage? Now, we have seen cases where there's bodily injury allegation. You know, and sorry, let me pause real quick. A lot of my perspective is informed by the supplement industry, cosmetics, food products. That's where I've done a lot of my work, where we do a lot of our work. Also with some, you know, tech manufacturing, but mostly with respect to Prop 65 in the food industry, wellness products. So anyway, the first thing they're looking for and what your policies are underwritten for is this exposure, bodily injury, right? So that's what they're charging you for. That's what they're underwriting. And so right out of the gate, they're not super excited about, you know, this issue, this lawsuit that's hit that's not, you know, no one's alleging any injury, bodily injury. Now, we have had cases where both happen. They claim there's a bodily injury and a Prop 65 violation. And you should know there are actually squirrely insurance programs out there that if there is a that type of regulatory allegation lined up with a bodily injury allegation, they'll deny the claim because the one half of it isn't covered. So anyway, just make sure your broker knows what's in the policy form. Okay, so general liability, not a great solution. Management liability, directors and officers coverage. Now this is, for a lot of, let's say plaintiff's attorneys, they see D&O is sometimes kind of a fallback for a type of claim that is denied on all other policies. Well, let's hit the management team, let's name one of the directors, and then there'll be a duty to defend clause. We'll have to pick it up and we can run up a bunch of costs. D&O programs, carriers are very aware of that and really don't want to be that. So I have seen cases, FTC cases and other types of regulatory cases where the cost of the investigation was covered under the management liability form. That'd be through an endorsement on the D&O policy. But Prop 65 almost never. They're really not trying to be a solution for that. Advertising injury liability, not really. Defamation of character, not really. That's not really going to come up. Professional liability, errors and omissions, maybe. You have a manufacturer's E&O coverage that some of the contract manufacturers in the room, your broker, your agent should be offering or at least discussing with you. If you do an entire fulfillment for someone and have it made, box it up and send it, and they have a violation, you could potentially have an E&O claim. But the claim would not be responding directly to the Prop 65 issue. It would be responding to your client's loss, meaning the MLM or whatever client you're working with. They had some financial loss because they had to deal with the Prop 65 issue, which resulted from your error as their manufacturer. That is possible. And a lot of these things, what happens is it happens once, and someone finds a way through the labyrinth of insurance, you know, coverages and exclusions and then give-backs, which are written by attorneys, so don't judge me. Good attorneys. You guys are great attorneys. Someone finds their way through that labyrinth and gets coverage on an E&O form, right, or a malpractice or a management liability form, and almost certainly the next renewal there will be a dead set exclusion against it. Because again, it's not what they're intending to do and is usually just spam, with some exceptions. So Prop 65 exposures don't fit squarely into any of these categories. However, sometimes there are sublimits, targeted programs that exist. Now let me start this. Let's see how everything pops onto the screen. Okay. Anyone had an experience with filing a claim with your insurance carrier on Prop 65, you know, lawsuit, litigation, throughout the process anywhere? Has anyone ever tried it? Huh. Who in it, by raise of hands, who in the room actually works directly with the broker, or who, is that your job to oversee the insurance? Okay. Now, I'm just curious if you've had any experience. So it does exist in present form. There are sublimits on policies specifically for Prop 65, okay? I'm part of why it exists. We created it. It's brand new, this version. So about 7, 8 years ago, there was a program that rolled out, hey, to be all things for the supplement industry in terms of insurance. We've got Prop 65, we've got everything, and the thing went bankrupt in 1 year because they covered a whole bunch of Prop 65 litigation, didn't have it priced right, and it didn't work. So now what you see, if it exists, is something like this. You have a $25,000 to $50,000 sublimit built into your general liability policy, sectioned off for Prop 65 coverage, okay? I'm not positive they know what they're doing or what they're getting into. So if you can get something covered, get it done now, and because it may not be here next year, right? That's just how Prop 65 has kind of gone through the years. Really important, though, if you want to do that, or you think you might remember on your application, you've got to indicate any Prop 65 fallout you've had to deal with, any issues that have come up, any other labeling, because otherwise when you file that claim, if you've had a history of it, that'll make it a little bit messy, okay? The other thing to keep in mind with that is it depends a lot on what your policy retention is, what your deductible is, how they factor that supplement, okay? But those do exist. So it's something to look for if you're judging between insurance products being offered and whatnot, if it's a concern. At the very least, and this is probably, you know, doing some log rolling, at the very least, if someone has put that on their form that they're offering to you, they have a decent idea of what your industry is all about in the issues you deal with. So it does tell you that much, if nothing more. I have seen other programs that are super industry specific, like Wells Fargo. This is not log rolling because they're my competitor. They got together with the Plastics Association and put together a Prop 65 defense coverage, pretty high limits, up to $500,000 or something like that. And it was super specific to that group and for 8 different chemicals. And so if you had a Prop 65 violation alleged or litigation that mentioned one of those chemicals, they would cover it. So there's some things like this that do exist out there, and I don't know if that one's still around. Very inconsistent, they come and gone. And really, as in the case of the perfect iteration with the supplement program offering a sublimit, it is a marketing ploy. I'm just going to confess it right now. That's why they're doing it. We're really not necessarily focused on addressing Prop 65 claims because the insurance industry sees it as what you've described and discussed and worked on today. It's a business management, it's a compliance issue. They see Prop 65 as one tiny piece of what should be a holistic overall approach to proper labeling, right, and to risk management within your organization, and don't want you to see your general liability insurance as the place to throw that stuff. To feel like you don't have an option usually means you dial in and join the ACC and do awesome things like this so you're as prepared as you can be, okay? So why am I here then? I had these existential questions. Does insurance do any good? Why am I here? Anyway, I was trying to get to you. Again, I'm here to say exactly this. Yes, there are some supplement programs. Yes, we offer it. Best practice is education of legal risk management compliance teams to prevent violations, provide defense. Very hard to do. You're still going to get hit, as we've discussed today, but that is the best practice, not leaning on the insurance. this sentence is probably poorly written. I brought this up because the reason it's so important that you're dialing into labeling compliance is because that actually has a lot of impact in other areas of insurance. I know policy forms that will deny the claim, policy forms that will deny a claim if the label was improper. That was not correct about what was actually in it. Now, most forms won't do that. They're just going to cover you, assuming it wasn't an ingredient that was excluded or something like that. But, you know, compliance to this and staying in good shape with your labels is what they see Prop 65 as being a small part of. Marketing. The reason I'm here today is because consolidated knowledge and education are how this is most effectively addressed, and we want to support the fine work of the ACC and give them money. That is the main reason you have to deal with me today, because this is an awesome organization. I've been involved with it for several years, and you have brilliant panel members, present company excluded, who offer really valuable advice and counsel. So please support, attend, come to the Nutritional Law Symposium. That is why we're here. Again, insurance may help ease the burden to a very small degree, and you know, Prop 65 as a subject may be a decent way to vet out the insurance broker you work with, make sure he's got some education in your industry. They are not underwritten and structured to respond to this type of exposure. I told you I'd be fast. Now, education of legal risk management compliance teams is the solution. This is a great organization. Please continue to support it with your knowledge, your experience, and if you're a sponsor like me, with your cash. Thank you very much. That is it. I'll leave some more time to finish your lunch and network, but did anyone have any questions about that?
Yeah, their insurance coverage under a CGL policy for property.
Absolutely, full limit. Yeah, buy an umbrella and just throw it at them. Yeah. No, there really was. It was an awesome program out of Northern California. They were right in the hotbed of what I would call the Prop 65 legal economy. And just to take it, sorry, don't be scared by the answer to this question, by how long it is to ask anymore, but with food products, supplements specifically, claims are rare. They're just huge, right? So several, people in the insurance buying public businesses feel like, well, we just never use this stuff, right? So these guys came together, built this great program, underwrote it through Lloyd's, and said, hey, you're never paying claims on food products, so let's offer this kind of more of a maintenance coverage, right? And we'll just gobble up so much premium and build such a huge program, it'll work. And it did not. It lost, I can't remember if it's 20 or 25 million in just a couple of years. So insurance carriers don't make much on underwriting margin, if any, but if they're losing that much, they'll have to move out. So yeah, so that's why now if it exists, we're trying to do it. We're trying to coach them to do it in a really strategic way. They offer a sublimit that you can underwrite for, that they can put into the whole pricing package, and at least give each of these companies one of these claims. Let them claim $15,000 claim. The issue is, again, coming back to what you discussed in the presentations with respect to legal expense and settlement, it just depends, but very rarely do these supplement programs include settlements. They're offering defense costs only. So even though it says $25,000, your actual defense cost might be, $5,000, unless you're working with a super fancy attorney like Holland and Hart. By the way, thank you, Holland and Hart. This room is fantastic. You're never invited to our office.
So can you give us a ballpark on the premium? Are you looking at one of these
It's a great question. You almost won't pay for it. It really will be, it will depend entirely on, okay, so say you're coming into, you haven't had any Prop 65 issues, right? but pretty sizable company, you know, 25, 30 million or more in revenue, they'll offer it. Because it's just more of a marketing to win your business, because they're charging you on the product liability rate is where they'll get it. Now, if you've had some issues, they'll either refuse to offer it, potentially, depending on how, you know, catastrophic it's been, or they might say, okay, we'll do this, but we're going to charge a little for the Prop 65. But I've actually never seen a charge for it. It's either we'll offer them Prop 65 or no. And again, it's something, but it's barely something. Just to reiterate, we just see so few product liability claims. Literally, in defense of all insurance brokers out there, we are trying to get their money for you. I want them to pay claims. We want them to cover it all, right? And so that's kind of where it stems from, is saying, hey, let's at least let them use this product liability policy a little more frequently. Trouble is, specifically with food products, when the claims hit or some hot ingredient, you know, gets a really bad rap, then we start maxing out limits really fast. So that's really what the pricing is based on, is those catastrophic events. Okay. Good? All right. Enjoy the rest of your meals, and we'll go from there. Thanks again to Zach for this awesome separating cake. Cheers.
It was actually ours.
So should I go on?
You can decide anytime if maybe we give people 10 minutes to finish up their lunch. Sure. And then do one more drawing. Okay. And then we'll have one for the very end.
Yeah, right.
To the end. So the important
Yeah, it's on there.
John Holbert, we have it on.
Yeah, I mean, again.
John Holbert? No. We try to avoid it, but after the I'm wondering if we really are.
You're one of those. So we have a program called NutriPro, built for the product industry. And we had you at CNA before, because that's more of a cosmetics, medical device type product liability specialist. We just were able to squeeze NutriPro, even though you're working inside their name, and the NutriPro product has it. And now it's untested. I literally introduced it in so that's why all this is claimed. But it does exist. It is on there. And if you guys get hit, I'll be telling them, this is your moment. You prove to me, well, no, you prove to me that it's real. You know, that's what I'm telling you. Like, this product, we kind of build ourselves with Lloyd. So it's a little different than typical. You know, we write the policy form. Well, we write it, and then the lawyer write it. Yeah. That's why they're working. They're not.
My last
yeah.
So we're testing on right? I mean, the trials. We actually have because we had
yeah.
And it's claimed that it will be. Anyway, we got prosecutors.
You pay for it. You pay for it.
And it wasn't even like a claim. We just pushed it out without
You really?
It wasn't even a claim. We were just trying to get our policies written.
No. We have, for a couple of the companies in the room, we have just to avoid that scenario. So you have the core general liability, and then have the trial supplement, and then there it's underwritten. So we get the schedules from and then they write it. So then.
The problem was,
when you bring it to a party, try to get a glamorous policy with that.
I start every process risk evaluation assuming the carrier is trying. You have to do that. So that's how it works.
For understanding.
Well, it's it's trial by fire is what it is. And that's how you. Yeah.
I just had to come say hi.
Oh, hi, are you?
How's it going?
Good. Okay, sorry.
Sold ourselves. That go okay? I'm Josh, by the way. You guys are awesome. You're having a great year. Yeah.
It's a great company.
Oh, I just had
But your legal team, Alex would say hi to it. Your year and a half was pretty high tenure. Yeah.
It was like this. Yeah. I'm sure I came off gratefully. It's so good for MLM. It's just so good.
I don't work with these specific. Some of the companies are making stuff too, and I know I've been trying to get your CFO. The CFO, former CFO of Luga, I think his cousin, that's actually such a great thing because now you've expanded, so it's trying to work and expand it. That's fine.
Yeah, I mean, that's going to be our job. No, I think it was smart. I mean, that's just I'll be retired.
Oh, good. Well, no, I have a lot of admiration. Great aggregator. No, when I drive by the field.
The way that it does, if you go down at the right time,
my client, the Barn Bullet guy,
very small
across the freeway. Those are a client of mine down there at Farmington. He owns Young Living Homes Encapsulated.
How many people are up there?
Pretty much his property owner. There's the BLM. It's a great company. Yeah. Network market space is crazy. Every usually so much of from the insurance is built so over 20 years writing covered the greenhouse things come and aren't covered or not.
I think so. But I mean, that's the number of our
Who were you with? I'm sure it's the way to go. From my perspective, I'm not sure about that. Rather than just executive and legal brilliance, I'm trying to figure out ways to attribute Young Living. You've been a great company for us. But I feel like there's something in my office is judging from my little stuff, like mom and dad treating their kids too loyal, but trying to do little medical because it's me. Some ways, news people, so many others. I feel like Young Living is the ultimate. Like you don't have to share, you don't have to. And now everyone's trying to put it out there. Yeah, but it seems like Yeah. Well, I know I'm well, thanks for putting up with me. Well, I am. Yeah, never get in trouble for moving short. Yeah, one slide. The original presentation was yeah, exactly. Well, it's nice to meet you.
And then, yeah, they try to keep you
Okay. Yeah, I guess. So, kind of fun. I'm ready to talk to C5, but you know, a lot of other things going on.
Tried, you know, since trying to diversify the message of it, you do cases nonstop, you're going to
Exactly. Right.
so
Drive you crazy. Yeah, after a while. Yeah, do something that's a little more interesting.
Indeed. And also, with the clients who are more
yeah, right, exactly. So, yeah, these are all settle in, settle out.
Easily keep me busy 1,000 hours a year.
So instead of replacing it, add it on top of that.
Right.
So work doesn't stop coming.
Right.
It's hard to say no to these cases. Yeah. So we hired him. His name is Sean, and he clerked for magistrate judge in LA, and then really excited about having another associate on board. So I'm doing a lot more class action work generally on a lot of stuff, CPA.
Yeah, which makes sense. So we were actually settled up, and there's a variety of regulatory stuff, but we still always got a lot of outlets.
I got it. Yeah. All of the point about DSPs is in and out.
And are you registered? No. Okay. I have like 5.
Anthony is registered law yet. I forgot they changed the rules about how much you need to do before you have to register. You're permitted to do some unlicensed. No, you did, really?
Yeah, when I realized that a lot of
Hilton or whatever.
Lots of folks but
Interaction is a generous word this way.
Yeah.
But tell my accountant, over me my back. Let's sleep easy. Like I love
Oh, I bet you are. So when I worked for the legislature, I had to write description that you had. Interested in doing a lot of things. You know, it's just weird to think about it because, you know, you never, I know probably I wasn't graduated. Like, right, of course not. So, you know, I just spent so much time. I just want to keep it going. I understand the economic concept of sunk cost.
For me, a lot of it is very like my rate is
Supervising, we're counting on you to do 5 hours.
Right, yeah, right. Like you need not at all. No.
Well, there certainly are. I'm sure this is true for you too, but we find them more eater practice. We get people in the door, we double fix them, or we fix their labels, and then tell our losses.
Here's the lawyers say
True, you're right, yeah.
I have this management things like that. You know, it's not just much of a honestly, I enjoy the problem.
Sure. Complaints are usually great.
Yeah. I work in working associates like this. They're much more, like, it's great. I actually resulted in a meeting the other day.
True, very true.
Because at the same time, they're working on something that is like, you know,
yeah. Yeah, yeah, every player has their canned speech, the initial, like, this is how it is.
Right, exactly.
Sure, right? Yeah. Exactly. You know, one day I hope you get to the point in my career where I can adopt the Harold Brody model.
Oh my God.
Which is to not take any cases unless the client agrees up front to take the trial.
Exactly. This one, we're just all the way on this one. She just fans the flames of their indignation about it. She had, you wrote Prop. Brokers.
I have.
Tom has a similar bombastic approach.
Yeah.
Yeah. And,
me too.
I've taken 2 cases. Oh, yeah, and one of them, and one over there. You know, from a client who just sort of America around here.
Let me tell you what my bills are. I want to say after that, all the next stuff.
to minimize.
What's your I've heard really ours was like a year before, yeah.
Wow. You ate your last.
Well, that was pretty much
Not that long ago. Yeah. Something big that was like just was on the phone with
I'm meeting somebody else from like, wow.
This will become under $50,000. You know, you're thinking all the time, and that sort of stuff. Yeah, I love it. Pine trees are really good shape. Yeah, like what you're looking at is a lot more. Oh, really? Okay, great. Okay, great. And now it's not.
The only feedback that we've had is
Okay, sounds good. So do you want to introduce me, or should I just
you guys
bring everyone to attention?
You guys ready for our last speaker? So our last speaker for the afternoon is Trent Norris. He's from Arnold and Porter, which is now merged. What's your full firm?
Arnold and Porter K. Scholler.
K. Scholler. Okay.
Not that much harder.
So, and I've invited Trent to come and present today, and his firm agreed to be one of our sponsors after actually listening to a webinar. And I think I'm on your email list for your firm. Right. And so I would just recommend anyone if you're, because you don't do just Prop 65 cases. Right. There was something on Antitrust a couple of weeks ago that I listened to. So you can sign up with Arnold and Porter. They have free webinars. They usually last about 35 to 45 minutes. Usually, you always have the slides available if you want them. And yeah, that's how I found out originally about the case topic that he's going to discuss. And I hope that if you guys have any questions, you will follow up with him, but also consider signing up for the webinar.
Great,
okay,
great. Thank you. Thanks very much. So I have kind of a grab bag of hot topics on Prop 65 to cover today, and then definitely want to get to questions and a discussion about, you know, things that haven't been necessarily clear in your head about how Prop 65 works at a practical level. So feel free to interrupt me in the midst of this as we go through it. Here's the topics I want to cover. How do chemicals get on the list? What is this naturally occurring exemption, and what's the cooking exemption? How do these work under Prop 65? This is important for food products primarily, but also for products that contain food ingredients, which oftentimes would be personal care products, for instance. Lead and what we call the beech nut backlash. Beech nut was a watershed case a couple of years ago, and it is in jeopardy. It was a ruling that the business community really appreciated and brought a lot of clarity to Prop 65, but that ruling itself is now in doubt. And then I'm happy to talk in greater detail about the new warning regulations, but I think you've had a lot on that already today, and it's just part of the slides. So I'll probably just skip past that portion once we get there. So the chemical listing process, you know, where does all this start? The best thing about Prop 65 is if your product doesn't contain a chemical that's on the list, you don't have to worry about Prop 65. So it's all driven by the list of chemicals, and there are 4 ways that chemicals get on the list. The one that is the most legitimate, if you will, is the first one, which is the state has a committee of experts who are appointed by the governor who review chemicals and the information on the chemicals and decide, is this now known to the state to cause cancer, or is this known to the state to cause reproductive toxicity? That committee meets once a year, usually in Sacramento. The members of the committee are paid what amounts to jury duty wages for coming in for a day to review things and to get lambasted by the public as comments come in on a variety of topics and then they vote and make their decision. The agency then takes the decision and implements it to actually put a chemical on the list. Any of these listings, from the day that the listing decision is made to the day that you have to provide a warning for it, is 12 months. So that's a grace period. It seems like a lot of time. The agency seems to think it's, plenty of time for anybody to do anything. But if you deal with product cycles, development cycles, food products, et cetera, 1 year can go by very, very quickly. So it's important to monitor these types of listings. The other ways that chemicals get on the list, an authoritative body can decide that a chemical causes cancer or reproductive toxicity. That could be a body that's been designated by the state's qualified experts as a group that is considered authoritative with respect to carcinogens or with respect to reproductive toxicants. And it can be a domestic U.S. entity, it can be a foreign entity, it can be a private entity, and there are 6 or 8 of those authoritative bodies for each of these endpoints. If they decide that something causes cancer and they publish it in a sufficiently formal document, there can be arguments about whether that's formal enough and what was it that they really said, but the agency will pick it up typically and it'll go on the list more or less automatically. The formally required label is hardly ever used anymore, although that's how lead got on the list. And this is just if the federal government formally requires products to be labeled with respect to the presence of a chemical, then it goes on the list. And it's not been used other than the initial listings there. It hasn't been used for a long, long time. And then finally, there's the labor code listing mechanism. And I want to drill down a little bit more on that because this is the one that surprises people. It seems to come out of nowhere. And it all relates to an entity called the International Agency for Research on Cancer. This only applies to carcinogens, and Prop 65 contains a provision with 2 embedded cross-references which says, in essence, whatever this group in France decides, and this group appoints a committee of scientists, chemical by chemical, from time to time, sometimes without much notice at all, in a very non-transparent process, and they all fly in and meet together in a conference room in Lyon, France. And if they decide that a chemical causes cancer, it goes on the Prop 65 list, almost without further review, certainly without any additional substantive review. And so this is how chemicals can appear all of a sudden out of nowhere, ended up on the Prop 65 list with a very low bar for getting on the list. The first time that this process was used to add a chemical to the list, other than something that existed prior to the passage of Prop 65, was in 2005, and it was actually the American Herbal Products Association that spotted this use for the first time when the agency took a new look at this statutory provision and said, you know what? Whatever this group in France does in the future also should belong on the list. No one had previously thought that that was the way the statute ought to be interpreted. And so there were 2 chemicals, then areca nut and betel quid without tobacco, which went on the Prop 65 list through that IR listing mechanism, notwithstanding APA's vociferous opposition to that and indicating that they thought it was illegal. The California Chamber of Commerce a few years later challenged this procedure for getting things listed, and they lost in that challenge. So that the Court of Appeal said, no, that's perfectly fine for this group in France to be making these decisions about California law. But fast forward a few years, and we now have a suit pending in which our firm represents Monsanto, and we're suing the state agency over their use of the labor code listing mechanism with a different argument this time, not one about what the statute says. The courts have already said the statute means that IARC gets to decide what goes on the Prop 65 list through this process, but instead taking an approach of saying, wait, this is unconstitutional. You have an unelected, unaccountable private body that meets in secret in France that can get together and write California law. That doesn't make sense. There are due process issues there. There are issues of delegating lawmaking authority irresponsibly, et cetera. And so there are motions to be heard on this in a couple of weeks. We'll see if what the trial court thinks of it, but we won't really know until this gets decided by the California Court of Appeal or the California Supreme Court. There are several listings right now, and I've got them here on the slide: nickel, titanium dioxide, benzophenone, pulegone, aloe vera, DEA, and mineral oils, chemicals that are on the list that should come off the list if Monsanto is successful in this one. And then in addition, there are other things. So one of them, you may have seen something in the newspaper about how they were listing bacon as a carcinogen under the IARC process, and that would have some impact on Prop 65 and could ultimately end up putting processed meat on the Prop 65 list. But for now, the agency is moving a little more slowly on that. So let me talk a bit about naturally occurring. And again, naturally occurring and cooking apply only to food products or to ingredients that are used, or food ingredients that are used in other types of consumer products. So the naturally occurring exemption, and I caution you at the outset, this sounds great. If it's natural in there, I don't have to worry about it at all. But as a practical matter, the provision's almost meaningless. It is incredibly difficult to prove that something is indeed naturally occurring. So it applies to foods, and it applies to food ingredients in consumer products. So if you've got an avocado face mask or something, and there's lead in the avocado, even though it's not intended to be eaten, the lead exposure that someone gets from the face mask is still subject to the naturally occurring exemption. It applies on a concentration level, not on an exposure level. So the idea is, you remember early on, prior speakers have talked about how Prop 65 looks at exposure level, micrograms per day. What's the exposure level to the average consumer? For naturally occurring, to determine how much of a chemical in the food is naturally occurring, it's a concentration level. It's a part per million, it's a microgram per kilogram, a milligram per kilogram, whatever. But it's a concentration level in the product that would be deemed to be naturally occurring. And if it is naturally occurring, and you can actually prove that it's naturally occurring, the exemption applies no matter how much of the chemical is present in the product, if indeed that amount is naturally occurring. So this is something that the activists don't like, because they look at it and say, why do I care if the lead in my fruit juice came from pollution or came from the soil, and where it was there for time immemorial, it's still the same amount of lead, but the regulations exempt any of the chemicals that are naturally occurring in a food product. So the best example of this, and in fact the one case where the naturally occurring exemption worked and was actually proven, had to do with mercury in canned tuna. There have been a number of settlements, though, as well about lead in calcium in some certain mineral ingredients, calcium, magnesium, and zinc ingredients, lead in herbal products, and lead in chocolate. So there's a variety of settlements that set a naturally occurring level that is deemed to be naturally occurring. Now, those settlements only apply to the parties to those settlements. So if your company signed up for one of them, you can rest easy. If you're not a signatory to it, though, the chances are pretty good, but not 100%, that a bounty hunter will respect whatever that number is that's out there already in other prior settlements. There's a very active bounty hunter in the dietary supplement space now called Environmental Research Center, or ERC, that has become very notorious and is no longer accepting the prior agreements that had been made, even ones that it made with competitor companies, about what's the naturally occurring level that's deemed to be present in the product. So just because, you know, you have a certain amount of lead in your product and you have competitors who have signed this agreement with a different bounty hunter in the past, doesn't mean that you're without risk. You may very well face this type of suit from someone like ERC. So the contaminants are usually what we think about, and I want to break down naturally occurring into contaminants and constituents. So, and the distinction is this something that is made in the plant itself? Is it always present in the plant itself? So a good example of that is pulegone, which is a carcinogen that is found in peppermint and in a variety of other plants. Beta-myrcene is another one. Golden seal, root powder is another that's on the list. So, you know, there are certain constituents of plants that are listed under Prop 65. They're treated differently for the naturally occurring exemption from contaminants like typically heavy metals, lead, cadmium, mercury, and arsenic, which are present in the environment and find their way into food products, mainly plant products. And for naturally occurring contaminants, the reason I say this is a real ephemeral exemption is that you have to prove, the business has the burden of proof for naturally occurring, and you, once you're accused of having lead in your product, for instance, you have to prove that the lead is not there from any human activity, that you have complied with good manufacturing practices and good agricultural practices. So your suppliers all the way back up the chain have to have complied with these practices, and you have to prove that you've reduced the level of the contaminant to the lowest level currently feasible. Nobody quite knows what that means, but it does seem to incorporate concepts of cost. So it's a very heavy burden of proof. You're essentially proving a negative. This lead did not come from any human activity. And since lead is present in pollution, and we used leaded fuel up until the late 70s, and a lot of it went into the atmosphere and got rained down onto soil where plants are grown, proving, you know, how much of the lead in the product comes from pollution versus how much within the soil originally is a very heavy burden, something very difficult to do. And in recent memory, in the beech nut case, the juice companies that were sued there, juice and baby food companies, spent in the 7 digits to try to prove that the lead that was present in, you know, the smashed sweet potato baby food was present in the soil originally, et cetera. And the court did not accept their evidence on this issue. So they lost on the naturally occurring side of things. Mercury in tuna is a great example where the industry succeeded at this, but they had a number of things going in their advantage on it. One was that tuna fish it's as if all the tuna in the world were grown in one field, because tuna swim throughout all the oceans of all the world, and the mercury levels in tuna are very much the same, no matter where in the ocean the tuna happened to have been plucked out of the sea. So they had that as one very helpful piece of evidence. The other, and so they were only dealing with one commodity, whereas if you're making a protein bar, you may have 14 ingredients in it, and they may be grown in all sorts of different places around the world, and you may not even have a line of sight into exactly where the ingredients came from. So getting back to the field level is going to be extremely difficult. And there can be a lot of variability depending on where the products were grown. But another advantage that the tuna companies had was that there is a great deal of evidence about how mercury is added into the ocean waters through volcanic vents that are under the ocean. And so they had great geologic experts talking about this. But their final sort of Perry Mason moment in the case was that they found a piece of fish tissue in an ichthyological museum in Scotland that predated the Industrial Revolution. Somebody had taken a fish sample, I suppose on some old schooner or something, and it was in this fish museum. They tested it for mercury level, and lo and behold, the mercury level in that fish was just exactly what you would find today. And so that was the perfect example of, aha, this mercury has been there from, not from pollution, but from time immemorial. So it's an unusual case, but it's, you know, it's a very helpful case, but it also shows, okay, this is what you have to do. It's a very heavy burden, very difficult to do. So naturally occurring constituents I want to talk about now, and here are the four main ones that you see often in plant products. And these are very important, pulegone and beta-myrcene are very important flavoring agents, by the way, and there are some others as well that come from plant products. And beta-myrcene in particular is a flavor and fragrance conductant, and so it's a very common component of fragrances, even if they don't want the particular basil taste of beta-myrcene. It's often used in a way that then other flavors are added into and becomes a common food flavorant, or in personal care products or cleaning products or candles or those sorts of things. But under Prop 65, if it's a constituent of the food, if it's truly a natural constituent of the food, the burden is simply to show it's a natural constituent of the food. It doesn't have to be reduced to the lowest level feasible, because that wouldn't make any sense. But it's very important to keep in mind that it's only the natural forms of these chemicals that the naturally occurring exemption applies to. And so, for instance, beta-myrcene can be manufactured in a laboratory as well with organic chemists. The manufactured version of it is not exempt from Prop 65 at all. And with the listing of beta-myrcene, we saw the price of natural beta-myrcene go up, as you can imagine, as big companies, cleaning product companies and others said, oh, you know, we can't use the one that we make in the lab in Switzerland anymore. Now we need to actually harvest the plant and obtain it that way in order to have the Prop 65 defense that's here. Now, the agency is helpful on these natural constituents because they are attuned to this, and when they've listed these recently, these are quotes from the listing documents. They have noted and used the words a natural constituent of a specific plant, for instance. So in these cases, you know, they're basically indicating to everybody, okay, this is not one that there should be Prop 65 litigation over. It's also very important, and here on the last two to point out, so golden seal root powder is on the list. Golden seal is not. Golden seal extract is not. Golden seal leaf is not. It's golden seal root powder. So you have to read these listings very, very closely. Aloe vera, this was one that came through the IARC process. It initially started out as, we're going to list aloe vera. It seemed crazy. Because you can buy it at CVS in a nice bottle and put it on your sunburn and it feels better. But ultimately what they came up with was aloe vera whole leaf extract non-decolorized. So that's the actual listing, and you have to think about that. So the agency has supported this view of what's a naturally occurring constituent. There's a very old letter dealing with a prior listing of a chemical called methyl eugenol, which is again a plant constituent that's used in flavors and fragrances. And the agency wrote a very helpful letter to us about 15 years ago on this. There have been requests that the agency repeat this letter with respect to pulegone or beta-myrcene, and the staff have said, you don't want to ask us that question. You're not going to get the same answer the next time around, so we haven't asked. And in fact, a couple of times we've tried to stop somebody from asking to say, please don't, because we're not positive we'll get an answer that's quite as good as the original methyl eugenol one. And we think the methyl eugenol analysis is accurate. We think the way they're reading the regs is correct, which is you can have as much of this as happens to be present as a natural matter. You can even concentrate it further. You can take it from one product and put it into another, and it still qualifies for naturally occurring, as a naturally occurring constituent. So, you know, we may see some activity on this, we'll have to see. But these are the types of chemicals that are starting to get listed more and more now, and a lot of it through the IARC process. So then you'll also have heard about the cooking provision. This is the other sort of special food provision of Prop 65. This was written when the regs first went into effect in the late 80s and early 90s, and it was intended to deal with what everybody knew at the time, which was that when you grill meats, you create some carcinogens. So if you put a hamburger on the grill, you will create some heterocyclic amines in that process, and some PAHs, some polyaromatic hydrocarbons, which are on the Prop 65 list. And so the food industry fought for a provision that said if the chemicals are created during cooking, they're exempt under Prop 65. That's not quite what the cooking provision says. It applies only to carcinogens, and it only applies where there are sound considerations of public health that relate to the cooking. The example given for sound considerations of public health is where the cooking is necessary to make the food palatable or microbiologically safe. And we have an argument underway now in a case involving coffee. So when coffee beans are roasted, you create acrylamide in the process. It's the same chemical that you create when you brown potatoes or toast, or it's in crackers and cookies and grilled asparagus and black ripe olives and a variety of food products, cereal, et cetera, but it's also in coffee. And so the question is, well, do you have to roast the coffee beans to make them palatable? Answer, yes. You can't eat green coffee beans. You won't get any coffee out of them if you try to make liquid coffee out of them. Is it for microbiological safety? No. Is the roasting that you do necessary to make it palatable? How much roasting is it necessary to make it palatable? You can make a very light roast, or you can make a very dark roast. So these are questions that will be litigated, and then it's not a full exemption for all the chemical that's created by cooking. It's instead it's extra credit in terms of what's the limit for that chemical before you have to give a warning. How much extra credit is anybody's guess. The agency, when it has looked at this issue as just a preliminary matter, has talked in terms of one order of magnitude, so 10 times the level. And I'll give you an example. So for acrylamide, the agency has proposed a Prop 65 default level of 1 microgram per day, which would be the exposure level to acrylamide that a business is entitled to give to the average consumer without a warning. So 1 microgram per day. And the agency said in their proposal, well, for breads and crackers and cookies, we will allow that number to be 10 micrograms per day, which actually would help with breads, crackers, and cookies. They'll all be below that limit. It doesn't help for all breakfast cereals. It doesn't help for coffee. It doesn't help for a lot of different products. But that's one way that they may apply it. And this summer, the coffee case is going to trial, and we'll get some answers from at least one trial court as to how this particular judge views the cooking provision. But that is still to come. So let me pause there before I dive into lead and the beach nut backlash and see if there are questions, or have I just completely befuddled all of you? Yes.
I did hear a comment that our own Jason Chapin is trying to fight for the U.S. to stop funding for IARC, right?
Yes, exactly. There's a lot of work underway. He's the head of the
Without
House.
argument saying, why are we funding this thing while we're there in France, right?
Exactly, right. He's part of the House Oversight Committee, or chair of the House Oversight Committee, I think. And there's a lot of questions being asked about IARC, in part because of the glyphosate listing. So glyphosate is the active ingredient in Roundup and a variety, and it's not just Monsanto, many companies make glyphosate, and it's a very effective herbicide. It's the most used pesticide in the world. And every regulatory agency that's reviewed it has said this does not cause cancer, and it's safe for use as directed. But IARC assembled a group of scientists who got together and said, you know, we've looked at a subset of the data, and we've decided it does cause cancer. And under certain conditions, it's a very weak carcinogen, but we think it does cause cancer. And that's piqued the interest, and it's not just that, it's the processed meats, it's a variety of things where the activist groups have learned that they can get IARC to make a decision that a regulatory body in a full open process is unlikely to make. So it's been their sort of practice to go that way. IARC about 10 years ago adopted a conflict of interest policy, which says if you or your spouse have worked for industry, essentially, you cannot be on the IARC panel. You cannot serve as a scientist on the IARC panel. But it's no problem if you've worked for Greenpeace or NRDC or even a government agency, or even if you've made your career as an academic on accusing a chemical of being a carcinogen, you're welcome to serve on this committee. So there's a lot of, a lot of questions about the fairness of IARC. And IARC, to its credit, says we are not a regulatory body, which is true. And they say at the top of every document they publish, they say, we're just a group of scientists, we come up with our conclusions, what regulatory agencies do with them is their business. Prop 65 is the one situation, though, which they just can't ignore any longer, where California has said by ballot proposition, no, whatever IARC says goes. And so there's really no further human intervention after the IARC decision, which is, and that's exactly what we're challenging in the Monsanto case. Lead and the beech nut backlash. So here I want to talk about the beech nut decision and then the various things that have happened since that time to deal with it. Now, lead is over 90% of the Prop 65 payouts have been related to lead since the beginning of the initiative. A majority of the cases brought have had to do with lead. And why is that? Lead is ubiquitous. It's present in small quantities in manufactured products, whether we want it there or not. It's also a very useful chemical, and it's present oftentimes for good reason in those products. And it's been a topic, it's something everybody knows about. Everybody knows lead is toxic. It led to the downfall of the Roman Empire, after all. It caused Caligula to go crazy, right? So, lead's something that's in the public consciousness, and the activists have been after it for a long, long time. Beech nut was the first really big case in which lead in food was going to be litigated, finally. And here the Environmental Law Foundation sued 40 companies that make baby foods, fruit juices, packaged fruit and vegetables, and claimed that the products expose people to more lead than the safe harbor level of 0.5 microgram per day. In this case, the defendants won by proving that they exposed people to less than the 0.5 microgram per day level for all of the products that were in the case. And that defense victory was upheld on appeal. They lost, however, on issues of preemption and naturally occurring. So they tried all three of the major defenses that we have in Prop 65 cases, but they succeeded on the very expert-heavy one, which was there's not enough lead in these products to actually require a warning. How did they do it? Well, it's a roadmap we've used many times in coming up to the litigation bar and in settling cases and in analyzing how you comply with Prop 65. And this is the basic way to do it. So you say, what's the average amount of lead in the product? That's your concentration level. And I'll tell you, Greg and I talked about this many times, the number of times we get, a client in an initial conversation and they say, well, I tested it and there's less than 0.5 part per billion of lead in my product, so I'm okay, right? And you say, no, that's parts per billion. Prop 65 speaks in terms of micrograms per day. So there's some factors here that you're missing in doing this. Don't confuse your units on all of this. You may have less than 0.5 of a microgram per kilogram, in other words, less than 0.5 of a part per billion in the product, but that doesn't mean you have less than 0.5 microgram per day of exposure to the average consumer. And so those other two factors that you need are the lower two here, which is what's the amount of that type of product that's consumed by the average consumer when they eat it. Often you think of this as serving size. what's the amount consumed per eating occasion, essentially, and then what's the average consumption period over which the consumer eats this product. So I'll give you an example. In the case we had recently about Pepsi, the average amount of Diet Pepsi consumed per eating occasion by someone who drinks diet soda is, not surprisingly, very close to 12 ounces. That's the standard package size that you see. Not everybody finishes the can, but many people do. There's a reason why that's the average package size, because the average person doesn't want 16 ounces, and the average person isn't satisfied at 8 ounces, so they went with 12. So 12 ounces is that middle number for Diet Pepsi. But then the average consumption period of time over which a consumer eats the product was surprisingly small. It was once every 3 days. For the average person who drinks a diet soda, they drink a diet soda once every 3 days. And we had a lot of trouble persuading people of this. Even the judge sort of had a cocked eyebrow on it, because everybody knows somebody who drinks 7 of them a day, right? And what you're not counting is the person who drinks 1 a week, or my grandmother who would have 1 every month or so. So those people get counted into the average as well. And in the beech nut case, they were able to take all 3 of these factors and show that for all of the food products in that case, everything was below this 0.5 microgram of lead per day number. So this is the fundamental way of deciding whether you're in compliance with Prop 65. And the judge in the beech nut case agreed with them on this. Now, there was a lot of averaging that went on in the case, and I want to break it down in the types of averaging, because if you're thinking about your compliance scenario here, you have to think in terms of you have a certain amount of testing that's out there. Are you allowed to average? Do you have to be concerned with the highest test level that you get on a given ingredient? How does it really work? In the beech nut case, the defendants averaged all of the lead concentration results. So the part per billion levels in the products were averaged. They weren't averaged as between apple juice and orange juice. That would be mixing apples and oranges, literally. But they were averaged within the category of apples, for instance, or within the category of sweet potatoes or peas or what have you. But then, and there's not a lot of controversy about that. And typically the range that you see there is about 1 to 3 times. So you could have a number of 0.1, you could have a number of 0.3. That's not such a broad range, and averaging in there is pretty well accepted because you're basically thinking in terms of a bell curve there. Where the real controversy erupted in the beech nut case was over averaging over time. And here the defendants averaged the consumption period over a 14-day period of time. So they were able to use consumption surveys where the government goes out and asks people what did you eat today? And they ask them this for 14 days straight, 2 weeks straight. What did you eat today? How much did you eat? And all those surveys get compiled into a big database called the NHANES database, which is maintained now by the Centers for Disease Control. And the expert in this case looked at it and said, for lead, because of the way lead behaves in the body, it doesn't matter whether you got 14 micrograms of it on the 3rd day in a 2-week period, or whether you got 1 microgram each day for the full 14-day period. Your body's going to respond to this the exact same way, the way the body processes lead. So that, in fact, the expert was testifying 30 days. A 30-day period is plenty short to even say this, but they had 14-day data and they only needed to go to 14 days. So in that case, the defendants used the 14-day number. And what it meant was that they could have up to 7 micrograms of lead, say, in a serving of peaches, if they could show that the average person who eats canned peaches eats it less frequently than once every 2 weeks. Because that 7 micrograms would be divided across the 14 days, and that gives you 0.5 microgram of lead per day, which is the level at which a warning would otherwise be required. And then in addition, the defendants in that case used the geometric mean to measure this. So, a little bit of math on this. The Prop 65 regs use the word average. And from grade school, we've all thought of average as add up all the numbers and divide by however many numbers you just added up. That's called the arithmetic mean because you're doing arithmetic. You're adding and then you're dividing. The geometric mean is different. You multiply all those numbers by each other, and you get a very large number, and then you take the nth root of that number. So if you have 2 numbers, you take the square root. If you have 3, you take the cube root. If you have 4, you take the quadratic root. If you have 16, you take the 16th root of that number. And what the geometric mean does is it accounts for outliers without letting the outliers really skew the average number quite as much as it would in an arithmetic mean. So there's lots of examples we use for this, but if you're looking at the average home price in Seattle, Washington, and you take a small neighborhood that happens to include Bill Gates' house and a bunch of other houses, Bill Gates' house is worth $100 million, the other houses are worth $200,000. The average house price in that neighborhood looks like it's north of $1 million, when, as a matter of fact, there are 90 homes at $200,000 each and one that's at $100 million. That would be, the arithmetic mean would be skewed by Bill Gates' house. If you take the geometric mean, you'll get a number more like $280,000, which is closer to it, and it sort of pulls you back a little bit more. For food products, the geometric mean is the way that most food scientists look at this and look at contaminants. And it's the one that the court ultimately accepted there because it deals with these outlier issues. And for food products, it really matters. So I put the distribution curves at the bottom. The first is a normal distribution, that's the bell curve. The second is the skewed distribution, often called the log normal distribution, because if you take the log of it, you'll get back to a bell curve. But the basic concept is that for food products, none of us eat the balanced diet that our mothers wish we would. We tend to concentrate our calories in certain foods that we particularly like, and as a result of that, you end up with a skewed distribution for many, many food products. So you have the person who, for whatever reason, their primary source of hydration is Diet Pepsi, all day long. And so you have an outlier, in essence, there, and you have to sort of bring it back to a mean using the geometric mean. The activist groups did not like this at all, and the agency didn't either. So the Beechnut ruling was that the defendants won on the 0.5 microgram per day for every product that was in the case. And there were hundreds of products in the case. But the naturally occurring we failed on, and we failed as well on the preemption argument. On appeal, the Attorney General filed an amicus brief, basically arguing against the form of averaging that took place at the trial court level. That was a problem for us. We didn't like the idea of having the AG against us, but the Court of Appeal was very focused on whether whether there was enough data for the court to rely on in the original averaging. And this was, there were only 3 samples of canned peaches. There was only 1 sample of canned pears in the whole data set. But it turned out the plaintiffs had never objected to this data set. They'd never said, gee, this isn't comprehensive enough. And they lost on those grounds. So the Court of Appeal upheld the ruling, and really at the Court of Appeal there was never any doubt about the methodology that the court used, which I've just taken you through in terms of how do you evaluate compliance. And by the way, this methodology works whether it's a food product or a cosmetic product or something that you touch in your hands. You have to look at, what's the exposure to the average consumer. We may know how much phthalates are in this clicker. We have to figure out, okay, for the average user, how much are they exposed to? And that's the measure that you would be using. And that's going to be a function of the concentration level in here, and also how the average person handles it, how much phthalates they get on their fingers, how much of that crosses the skin barrier versus how much I might ingest because I put my fingers in my mouth or I ate a potato chip and it transferred to the chip and then into my mouth. So, you know, it's always the same analysis, and these averaging issues are very important. So the first thing that happened after the industry won the BeachNet case is that a group called Mateel Environmental Justice Foundation sued the agency and said the safe harbor level 0.5 microgram per day is way too high. It's way too generous. They had a number of problems with this, one being that this was adopted originally in 1989. When it was adopted, there wasn't a single commenter out of hundreds. There wasn't a single commenter who said this number is way too high. In fact, everybody who commented say this number is way too low. And as Greg mentioned earlier, this is the lowest lead limit there is anywhere in the world. So, you know, so to say, gee, this number is too high, it's way too lenient, was really sort of a problem. We intervened in the case on behalf of the Chamber and the Farm Bureau, and won at the trial court level, with the court looking at it and saying, you know, the agency did this properly when they decided on 0.5, and we're not going to second guess it as a court. So, you know, this is the way that the safe harbor levels are set by the agency. They're only set for a handful of chemicals, maybe 100 or so of the 800 or 900 chemicals that are on the list. But those that are set, you know, the agency is due deference for the levels that it sets, and they're levels that industry ought to be able to rely on. The ultimate outcome of it, after a lot of scientific debate, was that Mateel lost that suit. It's now up on appeal. I think they're going to lose there as well because, again, there's deference owed to the agency on all of this. But more troubling was that the agency itself then took up a petition that was filed by another activist group, the Center for Environmental Health, and the agency said, you know, we think the BeachNet court got it wrong on a whole variety of issues, and we think the regulations need to be changed now in order to clarify what has been the agency's longstanding position, they said. They did this with a draft proposal. It's not a formal proposal because in California, if you make a formal proposal, you have 1 year to adopt it or else it falls into abeyance and you've got to start the process over again. So they put it out first as just a draft for comment, and they got a lot of comments on this. They were essentially starting the process of overturning the BeachNet ruling and resetting the way Prop 65 compliance is evaluated. So they had a number of parts to that. One was, let's change the speed limit for lead entirely. So not the way you analyze it, but just we think the 0.5 number is indeed too high based on more current science. And they proposed a number of 0.2 micrograms per day if the exposure was a single day exposure. But remember, I said, you know, in the BeachNet case, the court ruled that the exposure could occur once every 14 days. So you could have 7 micrograms on one of those days, and you'd still be under the half a microgram per day level. The agency said, wait, it's not linear. It all relates to the way lead interacts in the body. And so they laid out a whole set of intervals and numbers with a whole matrix that they would propose, and it went up to 8 micrograms per day on I think that was on a 1-year basis. So if you had something, all I could think of was like Christmas tree lights, you know, that you would put up once a year. There, you're entitled to 8 micrograms for that 1-day exposure that happens once a year. And they were basing this on science, and if it were adopted, they would be owed deference. But the important part is they were dropping the number from 0.5 micrograms on a single-day basis to 0.2. So it was a 60% reduction in what was already the lowest lead level that was already out there. And again, this is just a draft proposal at this point. They also proposed levels for arsenic in rice and for lead in foods that would be deemed naturally occurring. This was something that the food industry had sought for 20 years. You know, I've explained how the naturally occurring regulation doesn't really help very much. And the reason is just the enormous burden, the expense of dealing with it, et cetera. And so the food industry for years had said to the agency, just give us a number, a concentration number. Give us a part per billion or a part per million, that as long as we meet that number, we can rely on it, and we can know that that amount of lead in the product is indeed naturally occurring. And so the agency did this by looking at some geologic data, all from California, but still looking at it and saying, okay, so for lead in raw leafy vegetables, 8.8 parts per billion of lead is deemed to be naturally occurring. If you have less than that in an ingredient that is that's a raw leafy vegetable in your food product, in your smoothie or canned soup or whatever it is you're making, then you know that all the lead that's contributed by that particular ingredient is naturally occurring. And then for other types of food, they had a 6.2 number that they were proposing. These are pretty good numbers, and when we looked at it, we thought it's going to work for about 80% of foods that have lead in them, 75 to 80% of foods with lead in them, but nevertheless, we would feel better about a higher number. They also proposed numbers for arsenic in rice. There's a case pending now about arsenic in rice that they've looked at carefully, and rice happens to pick up arsenic very easily from the soil, and so these were levels that they felt would be okay. So this was the one part of the OEHA proposal that we liked. On averaging, they looked at the various types of averaging that I talked about, and they would require arithmetic mean, not geometric mean, which has a big impact. So for many food products, the arithmetic mean of the exposure may end up at about the 75th percentile. So if you've got 100 people that are consuming that food product and you take the arithmetic mean of their consumption, it's going to be at about the 75th percentile, meaning 75% of people are going to consume it less than that arithmetic mean. If you take the geometric mean, the number is more like 55th percentile. So that's why we say the geometric mean is much closer to the center of the curve and a better estimate of it, but the agency has been proposing to use the arithmetic mean, which just makes compliance all that much harder for food products. And then, just out of the blue, the agency came up with this idea that you cannot average the lead levels or whatever the contaminant level is across lots of a product. So if you're producing canned peaches and it's coming off the line and you say this amount is 2 pallets and that constitutes a lot, and then you have to characterize the lead level in that lot, and then the next time you get 2 pallets, you've got to characterize the lead level in that lot. And it's completely unworkable. If anybody who's ever done food processing knows, you know, the harvest is coming in, the peaches are being canned, they're all coming out continuously. Where you draw a line and say that was lot number 2 and that was lot number 3 is completely arbitrary and up to any business to figure out. And besides which, what the consumer gets is very likely to be from multiple lots in any event. So, so the food industry's been very actively opposed to this. But the agency held workshops on this, heard a lot from people. Ultimately, we were hearing back through the grapevine that they weren't persuaded by any of the comments. They were planning to go out with formal proposals on all of these ideas. And what's ended up happening is there's a discussion underway now between industry, which is primarily being organized by the California Chamber of Commerce, and key activists, which is primarily the Center for Environmental Health, to talk about, is there a way we can come up with a solution here that may be legislative, where we go to the legislature, which has to pass any amendment to Prop 65 by a 2/3 vote. Not easy to do unless you really have consensus, and say, what's the lead safe harbor level? Is it 0.5? Is it 0.2? What are we going to do it? How are we going to deal with averaging? How are we going to deal with naturally occurring levels? And that's a debate that's underway. Trade associations are very engaged in this and trying to figure it out, and so you may want to talk back through your trade associations about what the current proposals are and where we may go with that. But the activist groups have been actually relatively reasonable about this, and they don't want a lot of extra warnings on food products on the one hand. On the other hand, they don't want to give industry a free pass either. But they also don't like necessarily what the agency's been proposing. So we're hoping to come up with some sort of a compromise on that people can all live with. And at the moment, the beech nut decision is the law of the land, so, and will be until the agency starts in with a further regulatory process. which I think they would only do if the legislative process doesn't ultimately succeed. In the meantime, Mateel has asked OEHA to list lead for yet another endpoint. Lead's already listed for the 3 Prop 65 endpoint. Well, it's listed for cancer. It's also listed as a reproductive toxicant for male reproductive toxicant and for developmental. It's not yet listed for female reproductive toxicity, and Mateel is seeking to have it listed for that so that they can argue for a lower safe harbor level than the 0.5 microgram per day level. The agency has rejected the petition, and they then very recently rejected a request for reconsideration of that. So, and this is sort of what the possible legislation might look like ultimately. I'm happy to talk further about that. But that's basically what's been happening on lead. It's a very fluid situation right now because the agency is poised to adopt these regulations that would repeal what happened in the beech nut decision, which has been very good for industry in providing clarity and having people know what they need to do in order to comply with Prop 65. But there could also be legislative activity and some sort of grand compromise that says, okay, here are the rules of the road, at least for lead, going forward now. And likely sometime this spring we'll see something along those lines if indeed a deal can be reached. So with that, then I was planning to cover the new warning regs, but and I'm happy to do that. But I think that's been covered already earlier today, and probably makes more sense to use the remainder of our time for questions. And I know Greg is still here, Anthony's here. We can all field them. Did I do too much math?
Going back to the naturally occurring exemption, so the regulation requires that the chemical or the ingredient or the substance of it should be a food. How do you deal with the lack of a definition of food in California law?
Well, good point. So, well, we had a lawsuit about this, in fact, and the judge decided that dietary supplements are indeed foods for purposes of the naturally occurring regulation. The agency has agreed with us on that, and in the new warning regulations, there's some language that indicates the food warnings apply equally to dietary supplements. So it's being cleaned up a little bit there. The definition of food in California law, there's a variety of definitions in various statutory provisions that could be a lot more clear about it. It is not precisely equivalent to the Federal Food, Drug, and Cosmetic Act definition of food, unfortunately. But I think it's resolved now that dietary supplements constitute foods for purposes of naturally occurring regulation. I mean, in that case, we had a very passionate activist, you know, who was standing up with a bottle of pills and saying, "This is not a food, you know, this is medicine." And so we had to, you know, walk the judge through this thicket of statutory provisions to say, no, indeed, dietary supplements count as foods. I'm trying to think of where else we would have you know, something on the edge, though. Did you have anything else in mind on the food distinction? Yeah.
So for the new BPA requirements,
right?
I mean, there's something relevant to food and beverages.
Right.
The same definition of supplement as food.
Yes. It should. Now, the real issue there is they're supposed to be in cans. And there's a few other types of closures that are covered, but it's not every possible closure that includes BPA. So, you know, so we've had the question about a BPA liner in a plastic bottle. Does that count? And it's not clear under the regs. A lot of companies have reported under the database now, so that because they figure, well, I may as well get into this warning program, and then we can have an argument later about it. And those haven't been challenged by any bounty hunters yet. Yeah, I should say so BPA is very interesting, and here's another area where we're seeing a lot of activity. So the BPA warnings, right now, there are signs that are supposed to be present at every food and beverage retailer in California but there are hundreds of thousands of those locations, and you don't see the sign everywhere. But it's a little 5x5 sign that should be at the checkout counter that was sent out by the food industry and the beverage industry and the alcoholic beverage industry that is posted there and says, warning, canned foods and beverages contain bisphenol A, a chemical known to the state of California to cause female reproductive toxicity. For further information, go to, and it's the OEHA website on all of that. That OEHA website now, as of January 1, just a few days ago, was populated by submissions from the food industry of canned food and beverages that use BPA in the lining for the beverage itself. So bisphenol A is a chemical that's added to the epoxy coating that's on the interior of food cans, canned soup, canned peaches, canned green beans, and soft drinks as well as beer cans. It's also on the exterior of soft drinks and beer cans, and it's what keeps the label intact, so in shipment and otherwise. And so it's now on the Prop 65 list as a female reproductive toxicant, and activist groups are trying to get the food industry to phase out of using BPA entirely. The agency has tried to draw kind of a middle line here and allowed a special safe harbor warning program, which is this sign at the store level plus the URL that leads people to a website where they can look it up and say, gee, is my can of Budweiser covered by this, or my Del Monte green beans covered by this or not. And it's going to be interesting to see whether people actually are going to this website and looking it up ultimately. But that warning program will last only until the end of 2017, at which point it will no longer have safe harbor status. It may still be used, but it won't have the state's approval as an appropriate method of providing warnings. But it's a very interesting development for the food industry, which for years has sought a form of warning that might be at the front of the grocery store. And years ago, early days of Prop 65 in the late 80s, the grocery stores and the Grocery Manufacturers Association all got together, posted a sign at the front of grocery stores in California that said, some of the food we sell you here contains Prop 65 listed chemicals. For more information, call 1-800-PROP-65. This was, of course, pre-internet, pre-smartphones, et cetera, and so and you would dial up 1-800-PROP-65, and it was even before, the SKU numbers and the barcodes that exist now on all food products. So you'd have to call up and say, I have a can of S&W green beans in my hand, and you'd go through a series of voicemail prompts, and ultimately, presumably you would get a message at the end that said, yes, that product has a Prop 65 chemical in it, or no, it doesn't. But this was challenged in court, and it's very unfortunate. The court ruling was that warning method was completely insufficient. It was not clear and reasonable under the statute, mainly because it was so clunky and it took so much time for the consumer to do it. And the court looked at things. The record has information as well. The consumer's got to go to the store. They have to write down the phone number because, of course, people didn't have phones in their pockets in those days, and they've got to come home and then dial the number with the can in there, and they've already made the purchase, before they actually. That's not a clear and reasonable warning. What the agency's new warning program for BPA is, we think, a good exemplar of how you could do a warning program where you don't have to have it on the label of the product, which is always the problem, because if you had to have it on the label of the product, it means it's going to show up in Vermont and Alabama and Wisconsin and, God forbid, Canada, where people are going to freak out when they see these types of warnings. Having a product that still looks the same no matter where it is in the world is very useful for companies. And then for Californians, they can actually go to a website and figure out, gee, is there a Prop 65 warning for this product? So ultimately, we may get to the point where the smart label would satisfy that requirement. That's you look at it, take a picture of it with your smartphone. There's a special QR code, leads you to a website that tells you a lot about the product, allergens, GMO, where was it produced, you know, is it organic, you know, all those sorts of things, coupons, recipes, Prop 65 information. So that's, it's something of a dream, but something that the food industry's been moving forward, and the dietary supplement industry. Yeah.
So with all the work you've done on this Prop 65, have you done any research that, I mean, you talk about these warnings being clear and reasonable, but effective. I mean, do consumers even, I'm curious to know if anyone's done any research and said to the consumers,
right,
do you read these warnings and do you care? Does it actually have an impact, affect your purchasing decision?
Yeah, exactly.
I left Disneyland. Oh. Gave me a ton of cash.
That's too bad. That's too bad. Our two friends actually collaborated on those warning signs at Disneyland. So yeah, exactly.
But have you done any research?
There's a little bit of research on it, a little bit of anecdotal research, and we've worked with some experts sometimes on the issue. So there's nothing that I'm aware of that's really comprehensive or published. You know, they're good examples. Food products, I mean, obviously the sprinkler valve, the spray paint, you know, another warning isn't going to change anybody. Pesticide, another warning is not going to change anybody's behavior. Food, dietary supplements, personal care products, you know, these make children's products. You know, companies work hard to try to keep those types of warnings off the product if they can avoid it. But the best example was Starbucks. So I mentioned the coffee case, which is going to trial this summer. Starbucks was the first food company to really take the leap and say, okay, we'll put a warning, it's going to specifically mention coffee, and it's at the condiment station in Starbucks in California. It should be. It's not always, but it should be posted at the condiment station there. And they had fewer than 100 calls or questions to store managers and 800 numbers and that sort of things when these went up all over California. And coffee consumption is what it's always been. So really no impact on it at all. And it's really, you know, it's this conundrum. In the ethics session, we were talking about this, isn't this crazy? You know, the idea behind Prop 65 was companies will be so unwilling to put that warning on their product that they'll do everything to reformulate the product and avoid it. And that is true to a great extent. I mean, products that can be reformulated without an enormous amount of expense are reformulated. There is less lead in products today because of Prop 65, undoubtedly, and that's true nationwide, probably worldwide. You know, but then there are, the question is, was that achieved at the appropriate cost or in the appropriate manner? Those are big questions. But also, then there are products, though, like coffee cannot be reformulated. The acrylamide levels cannot be reduced in coffee and still make coffee that people will want to drink. And so there's nothing you can do but provide a warning for it. And the agency and the activists don't like that because they see people ignoring warnings. And the more warnings you have out there, the less likely people are to adhere to any of them or take them seriously. And it's a serious problem. And it's why the industry has said to the agency, look, you spent 2 years on the wording of the warnings and what the symbols should look like and all this kind of stuff. And that's not the real problem. The real problem is there's all this uncertainty about whether you need to give a warning or not. And everybody who has thought about it will err on the side of being careful and putting a warning on the product. And then you're going to have extra warnings everywhere. Right?
Hey, Trent, do you recall what the agency, did the agency hire UC Davis to look at that? They did, didn't they?
Yeah. To look at it, they did a study. Well, they looked at primarily the expense of warnings. Remember, that was when we challenged their regs and slowed them down because they hadn't done the economic analysis of what would it cost for people to change the warnings. But they did some sort of survey data on, you know, and mostly what they came up with was when you ask people, would you like to know the name of the chemical that's in the product? Not surprisingly, people say, yeah, I'd like to know that. It doesn't mean they do anything with it or that they behave any differently. But if you ever ask anybody, would you prefer more information or less information, right? That's the answer, more information. So, you know, I don't think anybody felt that was all that, you know, determinative. In fact, I mean, we've had an expert, our expert on the Disneyland case, in fact, opined that the number one thing that a Prop 65 warning does, and the bigger the word warning and the bigger the symbol, the more likely it is people will look right past it, because it's not what they're looking for. They want to know where's the bathroom, where's the ticket booth, that's what you're looking for, basically. And you see that and it's a warning, I don't need to look at it right now. So it's very interesting, the psychology of all this. Any other questions? Other specific chemicals, products? Yeah.
Last year, FDA, revised their reference amounts for
customarily consumed, the RAC.
Consume amount. So you use the soda example. They're going from, I think, 12 ounces to 20 ounces one serving. How do you see this playing to the California thing? Where now, because your amounts were at 12 ounces, now it's 20 ounces a day serving.
Well, that's the RAC is determined actually using the same database that we look at to figure out the consumption rate. This NHANES, the National Health and Nutrition Evaluation Survey, the NHANES database, and the FDA looks at the same data to try to figure that out. But they put their finger on the scale in various ways that's aimed at policy decisions. So, so they look at it and they say, well, there's enough people who drink 20 ounces of soda in a sitting, thanks to fountain soda available at a convenience store, for instance, that we think that ought to be the number that we use, and that'll help people do the math more easily, or whatever. It shouldn't affect Prop 65, because Prop 65 still is about the average amount consumed by people who consume that category of product. And by the way, it's a very important distinction. It's the category of product that you're talking about. So when I said Diet Pepsi, really the category is, you can have arguments about this. Is the category soft drinks? Is it diet soft drinks? Is it diet cola soft drinks? What's the appropriate category? Oftentimes the numbers don't matter all that much. But you're not entitled to look at your product and the average consumption of your product. So we often have clients who say, well, my product's not all that popular, there are not that many people who consume our product, so it's not as widely available, et cetera. But the answer is you don't get to expose people to more chemical because your product's not very popular. You have to look at the entire category of products, basically.
And how does that interact with your own recommendation when in your product label you say, well, 1 to 2 servings a day, or 1 to 2 packets a day?
Well, right. So that's a good question, right? So for if you're labeling as a supplement, you're typically giving a dosage of some sort. If you're labeling as conventional food, you're not. So no, the potato chip bag didn't say have 1 per day, right, on it, and the soft drink doesn't either. The ERC and other activist groups that are going after dietary supplements will hold you to what your label says. And if it's not on the label, they'll hold you to what your website says. And if your website says, this is good for breakfast, lunch, and dinner, they'll say, aha, that's 3 servings a day. And that's the way they'll force you to do the math. As a legal matter in court, you're entitled to look at how do people actually consume this. But the case is harder if you've already said, here's what we recommend. So in general, our advice is try not to recommend overconsumption. And sometimes there's pushback from marketing on this. Yeah, exactly. And but we often ask marketing, really, just because you say it's good for breakfast, lunch, and dinner, are people really going to have it that much? Would you be better off saying, this is part of a balanced diet, you can have it at any meal? Doesn't that communicate just enough? Or
justify their existence, they're always going to say yes.
Yeah, exactly.
We do sell more.
Right. That's the idea. But so the plaintiffs groups do look at the 1 serving, and they look at then the daily amount that is suggested, and typically they will they'll adhere to something like one serving a day as an appropriate level. You know, but it's kind of, it is interesting to sort of argue through those consumption rate scenarios.
And with ERC, it's been sort of like a chess match with dietary supplements, where a lot of companies started to change the labels. They're a little bit more ambiguous. They used to aggressively say take one before each meal or one before and after each meal. You see less of that now. And in response, now what ERC is doing is they'll email marketing people from your company and be like, hey, you know, we like your product.
Yeah.
Is it okay for me to take it 4 or 5 times a day? And of course, the marketing guy on the other end, yes!
Of course, yeah.
Right. And then so they said that extraordinary exposure test is what the hell is based on? This email.
Yeah.
They literally will send the email to us and say, this, you guys are telling people to eat these. And so you got to be, you know, that's not a good legal argument, but it's what starts there in the negotiating position way up.
Yeah. Yes.
So is there any actual data as to how many people actually contracted cancer or had reproductive health issues because of ingesting these food products that are subject to these cases?
No, not at all. No.
So it could be nobody.
Yeah.
There is one study, actually.